Hello, everybody. Hello, welcome. Good to see you. Hello, welcome. North Carolina. Well, come on in. Good to see you. Hello, yes, good evening. Good evening. Good to see everybody from England. Well, hello. Good to see you all. Bigly. Oh my gosh. Joining at the start. Well, welcome. Yes. Oh, from Pennsylvania. Hello. Welcome. Oklahoma. Kristen, love to see you. Love to see you here. Hazel from the UK. Okay, welcome. Virginia Beach. Okay. Wow. My goodness. Well, happy Tuesday, everybody. Is it Tuesday? Do we make it from Texas? Hello. Good to see you. Hello. Oh my gosh. Oh my goodness. Yes, it's Tuesday from outer space. Okay, I wasn't sure, Kristen. I wasn't sure where you were from. Michigan. Oh, great. We love that. Good to see you. Illinois, Arkansas, upstate New York. Oh, I bet it's beautiful there. Arkansas. Hopefully the weather's good. Vegas guy. Woohoo! Yes, Vegas is on my list of places to visit. Oh, Kentucky. We love that. Good evening. Hello from the International Space Station. Thanks for coming all this way to join. Florida. Oh my gosh. We love that. Maryland. From where Jack Smith's from. Okay. Idaho. Oh my goodness. From all over the place. Oh, I love it. Yes. From Maryland. Yes. Surprised you have the class clown. Really? I'm shocked, Kristen. Shocked. From the moon. Oh my gosh. We love that also. Upstate's cold right now. Okay. Mississippi. Mar-a-Lago. Oh, Dan. Okay. Hello. Hi, Suze. Welcome in. Oh, Toronto. Hello. Welcome. Washington, Alabama. Oh my goodness. Steffi, I saw Miss Fonnie in action today as well. She's a firecracker. We love that. Hi, Hawk. Good to see you. Wisconsin, Utah. Oh my goodness. Yeah, she was on fire today. Oh, Harlem. Oh, love that. Boy, it's been a long time since I've been in Harlem. Illinois. Hello. Welcome. San Diego. Going to be the most hard hitting against Trump. You have a good point. I think there's a lot going on. In the Georgia case. Well, Suze, I tell you what, I've got a new system I'm getting. I tagged you in a video. Did you see it? Oh, Sarah, I'm not sure. I'll have to check after the live. I have caught a few. I'm not sure which one was it. San Jose in Michigan. Oh my gosh, ¿cómo está? Yes. Doing well. Thank you very much. So yes, we did see her today. I am getting some things set up so that we can watch the hearing together. So hopefully I'll be able to get that going within the next few days to kind of do a little. Did you get your laptop fixed? No, unfortunately, I have not gotten it fixed. I'm not sure there is a fix. So it was hilarious. It was Trump's Sound of Music. Oh my gosh. No, I've not seen it, Sarah, but now I'm going to have to. So yes, Miss Fonnie, I watched the hearing. So she was in, of course, talking about Floyd and revoking his bond. And the judge ultimately decided not to revoke it. And I can see where he's coming from. But it was just fun to listen to her argue. It was just very fun. So I do plan to do a live stream going through it because it was recorded. So, and I'll kind of stop and go through it a little bit. So I will get that set up. But yeah, my laptop, unfortunately, I don't think is going to be able to be salvaged at this point. Oh my goodness. So it's taking me a little bit to get things replaced and set back into place. So she was on fire. She was very fierce. I liked, there was one of the things that she said when she came back up. So she gave her opening, and then defense put in their bit, and then she did a reply or rebuttal, and she came up and she said, well, my people are telling me I was too intense, so I'm going to tone it down. I mean no offense. Oh my gosh. So yeah, she had wanted to revoke it because he had been putting a whole bunch of things out on social media regarding the election person that he's named in the indictment as kind of, being unpleasant to. So pulling that back in, that was violating conditions of his release. So I missed that. Yes. I think it's only because, there are times when we all have to kind of bring it back down again. bring down the roof a little bit. You calm it back down. Put the tiger back in the cage is how I would put it. Sometimes you have to do that. So with new HP laptop, really? Oh, well, I should look into. Yeah, I'm gonna have to get it replaced. Everybody, I'm so frustrated. That was an expensive bad dream I had. Oh my goodness. So. Yeah, she was chomping at the bit. She was ready to go, but she's been working so hard. I mean, these prosecutors and judges, everybody's been just working so hard, and it's exhausting because, of course, we had the oral arguments yesterday in D.C. and Jack Smith was there, and I mean, these guys are worn out. They're really not that expensive. True. And it's not really the expense. It's just a matter of kind of moving everything from one place to the other. So it's more kind of gotta get myself sorted out here. I'm a little bit behind. I'm a little bit behind. I'm trying to stay on top of everything. She was big bad today. I think that was very accurate. Do it on Monday, Cyber Monday. Yes. Yes, that's a good idea. If there is a time to have to replace a laptop, it's okay. This is an okay time. Add in the wrist. Yes, there were the medical bills. X-rays are expensive for sure. Just finished watching the hearing. Yes, it's very interesting. I do plan to live stream it. I also am planning to do a live stream going through the oral arguments on the gag order as well, too. So I've got a list, everybody. I've just got to get my computer up and running. Oh my gosh. Use the cloud to move. Yes. Well, and I've got things in lots of different places. I'm pretty old school, but at least part of it is part of it should be okay. Oh, we will see, but I'm hoping to have that up soon. President's Day, the 2 best days for tech sales. Really, really interesting. Would like to see the hearing. Yes, it was I thought it was a great hearing. I thought Judge McAfee did an excellent job. Kind of, I guess how I would put it is he kind of like batted the lawyers back a little bit and was like, okay, let's stay on target, everybody. Yes, it's on TubeView. Yes, exactly. That's exactly where I watch it. Judge McAfee has, it's not his channel, but it's his name and on YouTube. And so you can go and pull it up and all of it's recorded. It's all streamed live during the hearings and then they do a recording of it. So yeah, Fonnie was awesome. She was rocking it today for sure. But his attorney was doing an okay job too. I thought he did good work, as far as trying to get his point across. I thought he did a pretty decent job. So yeah, it was very interesting. So I do plan to, have that up and going, at some point pretty soon. What was the hearing about? So, Fonnie had filed a motion to revoke Floyd's bond because he had been posting things on social media regarding the election worker that he's part of with the indictment here. So why do you think Cannon denied the SIPA hearings? Well, right now the Florida case is a little bit in limbo. So I'm kind of waiting on to see what the next order will say. I think that'll tell us which direction we're going in at this point. I think there's a lot of questions. And I think I just posted on my TubeView channel my live stream that I did on Judge Cannon. So, and on the opinion where she was reversed by the not the 8th, the 11th Circuit. So I've got the 8th Circuit in my mind at the moment, but yeah, so I do have that kind of up and going on my Tube of You channel. So hopefully we will see, though. I'm keeping an eye on that right now. But welcome, everybody. Welcome, welcome. So tonight I've got Trump updates. That's mostly what I have. We've got the protective order out of Georgia. So a couple of things out of Georgia, really interesting. I'll walk you through this protective order. We did have a very interesting hearing today. I will be doing a live on that. Does SIPA have a time limit? Oh, I don't think so. I don't think so. Looks formidable. Yes, it is. It is. And then I also have Fani's motion for when she would like to have trial set. Now, there were a few other motions that had been filed in Georgia. Chesbro filed one talking about, how he's needing the judge to allow him more travel because there are multiple states now asking Chesbro to come to their states because they are doing investigations on election interference. Right now, my understanding is New Mexico and Arizona are both trying to pull him into their states to talk to him about their ongoing investigations. So those are 2 states. So he's got that going on right now. Hello, David. Good to see you. Oh, look at that dream team you've got. We love that. Thank you for doing this. Oh, you're welcome. Of course. So he has filed that. Trump has also filed something in Georgia asking the judge to kind of contact Judge Chutkan in D.C. I'm not going to go through those particular motions. They're not very good, and I'm not sure what's really going to happen at that point. So got the YouTube notification. Okay, good. We love that. We love it. I hope he gets to visit them all. Well, I don't think he realized what's going to happen because he pled out in Georgia, as we all know. But, there's lots of other places going on. So anyway, so I've got those, a couple of those things that I'll go through here for the Georgia case. And then I do have an update out of the D.C. case. So I've got a couple of motions, an order from the judge going over that motion to strike. So I'll be updating on that one as well. Shift tonight. Yes, he is a flipper for sure. Pulling out all the stops. Absolutely. And there are many. So those tonight I'll be really just focusing on the Georgia case as well as the DC case. Florida is a little bit in limbo at the moment. So I am waiting. She has not put out anything new in the last couple of days, so I'm just kind of waiting at this point to see which direction her next order is going to go in. So I don't have anything solid. And as for the New York civil case, I don't have much of an update out of there either. So at this point, we'll just be focusing on Georgia and the DC case. So yesterday, we did go over the Colorado 14th Amendment case, went through that entire order and decision, which was very interesting. Lots of interesting new bits to talk about. So after tonight's update, I did want to let everybody know I will be coming back on again tomorrow. I know we're kind of in our pre-Thanksgiving moment here. I had wanted to go up on YouTube, but I'm not quite ready yet with my technology to go back up on YouTube. So I will be here on TikTok tomorrow. And I do plan to go through, I've got 2 special documents. I will be going through the Mayflower Compact along with the original treaty between the United States and the Cherokee Nation. So I'll be going through those 2 documents tomorrow. That will be on my schedule for then. So, but tonight we're going to dive into Georgia and we're going to dive into DC. So let's do a quick recap on what's been going on. So, we've got That'll be, yeah, I think it'll be really interesting. So just as a friendly reminder, everybody, it's been a while since I've been through the indictments here. This is the Georgia indictment. I am planning to do a live soon, going through how I annotate my indictment. So I will take you through a clean copy and go through and annotate. That will be one of my next lives. I've got that scheduled out. But just so that everybody knows, just to remind everyone, this is the Georgia indictment here. We have all of the counts listed out. Now we've got 41 counts total. There's one on the back. The big count here, of course, is the count number 1, which is the violation of the Georgia RICO statute. So the RICO is the Racketeer Influenced and Corrupt Organizations Act. This is where there was a plan with a group of people with a common goal. So everybody got charged with that. Brace yourselves for the face. No, Frank. So everybody got charged with that. The big thing, too, about the RICO charge is that it's a minimum 5 years prison. So we do have several people who have pled out at this point, and they've pled because they were able to get the RICO charge off the table. So that was a pretty amazing. But we've got multiple charges. We had a total. We started with 19 defendants. Now I'm going to show you the picture, Frank, so be careful. So here's the picture. We have all of our 19 defendants set out. We had Mr. Hall pled guilty first. Then next up we had, let's see, was it Ellis? And then, no, it was Powell and Chesbro pled out next, and then Ellis pled out. So told you, yes, you're right. I know. Cover your eyes, everybody. So we've had 4 of the 19 that have pled out, and they were able to get the RICO charge pulled. So Mr. Floyd's the one that had the hearing today regarding his bond revocation because of statements he was making that were threatening and discussing the facts of the case on social media. So he had his hearing today. I will go through that on a live soon. Mark Meadows, right now, he has his appeal. He's trying to get his case removed to federal court. He has been told repeatedly that's not going to happen. He continues to appeal it. So he's got briefs and arguments coming up to try to get his case removed. There's a statute that says if you're a federal employee, it's possible you could potentially get your case moved, but they're saying he was not working within the confines of his position when these allegations occurred. So we'll see what happens with that. So that's what's going on with Meadows. Cuddy, she was with Floyd and with Mr. Lee regarding the election worker and the intimidation that was involved in that. So she's been charged with that. We have Mr. Still here, who was one of the fraudulent electors. So he's been charged in there. Clark, he was one who had come up, one of the original planners of the fake elector scheme. He's an attorney out of the Department of Justice. He was. Right now, he's fighting hard for his law license. He's not having very good luck with that. So he's also been charged. We have Mr. Roman here, and he's an aide who was involved in it. So he's from Mr. Trump's world. This is Miss Hampton. She is the one who actually leaked the videos of Powell and Ellis and Chesbro's proffer statements. She's the one that leaked the video. So that's her. Mr. Lee here again was involved in the intimidation portion of the Georgia case. There's multiple pieces to the Georgia case. Mr. Cheeley is an attorney who was involved. Mr. Eastman was another one of the original planners when it came to this idea that the vice president could somehow overturn the results of the election. He was involved in that. Mr. Schaefer was one of the false electors. He's out of Georgia, out of the Republican Party out of Georgia there. Giuliani, I think we all know who that is. And Mr. Smith is an attorney locally, and he was also involved. So that's kind of, and Miss Latham, she's kind of up here too. She was involved in the Coffee County. She opened the election office and allowed for people to come in and access information that they didn't have access to and they shouldn't have had access to. So she opened the door. She actually is one that has one of the most numbers of charges. So I'm surprised she hasn't pled out yet. It would absolutely be in her best interest to plead out. But we do have Ms. Powell's involved in Coffee County. Mr. Hall was involved in Coffee County. So we already have two people from the Coffee County element that have pled out. So she's going to need to get in there with some good information. All right, so that's kind of the update on this cast of characters here. Yes, make sure to use your sarcasm emoji, everybody. People, yeah, they certainly are. More people haven't pled guilty. I think it's coming, everybody. I think it's coming. Now, again, just to come back to Mr. Floyd, he had been making multiple posts, and so there was a hearing today, and we did get to see Fani argue that case. The judge did not revoke his bond, but is going to put out some more parameters on that, order. So he had to agree to certain conditions in order to be bonded out. And so the judge is going to kind of make that a little bit more specific. And they asked, his attorney asked for that too, and said to the judge, Judge, sorry about this. We understand. We didn't realize this was going to get out of control. And one of the arguments his attorney said was, if they had just called us, we would have taken down the posts. So interesting argument. So we will see what happens. So it will be modified. But his bond was not revoked today, but that was his hearing for today. So that's kind of an overview on Georgia. So the big news that had just most recently come out of Georgia was that we had Sidney Powell, Cheesebro, and Ellis had given proffer statements. Now, the videos of these proffer statements had been released to the press, and now you've probably all seen them cycling around. So Fani Willis had requested a protective order on the discovery element. So she said, hey, we need to kind of protect our evidence here. So if you want to come see our evidence to all of the defendants, you need to come to my office. They had a hearing on it, and then the judge did issue a protective order. So that's the first thing I'll take you through here, is this protective order that Judge McAfee has put into place. So I see that if they overturn the gag order, will set a bad precedence. Yes, there's a lot going on with the gag order, everybody. There's a lot going on with both of the gag orders. So I'm going to be doing some posts just on that. Thank you for your hard work. Oh, you're welcome. Of course. This is fascinating. It's a fascinating time. Okay, hopefully I'm in frame, everybody, and then I'm going to go ahead and dive right in. Was that today? The revocation, the bond revocation hearing was today. Yesterday were the oral arguments on the DC gag order. So no decision has come out yet. So, yep. All right, so let's go ahead. Will he ever be convicted? We shall see. So let's go ahead. Looks good. Okay, thanks. Appreciate it. Post-it note. Thank you. Hazel, thank you. Excellent. Let me grab my sticky note here. Sticky note time. My terrible writing. Right, lawyers, don't innocent people plead guilty every single day in our country? I'm not sure. I guess, I don't think innocence is black or white. I think that people plead to lesser charges. I don't know that people blatantly have been completely falsely accused of false charges and then just plead guilty all the time to those false charges. I don't believe that happens every single day. But people do plead down to lesser charges. All right, so this is the Georgia case. Again, I'm not saying that there aren't charges out there that aren't very good. You're not a real attorney. Oh, I assure you. I've got the loans to prove it. Georgia case, and this is the protective order. So here we go. Protective order on discovery. Okay. Oh, Sarah. Criminals want us to think they're victims. Well, there are people who are innocent, who are unfortunately pressured and pushed into a position where they do go forward and admit guilt in order to kind of move their case along. But those cases are not as frequent as people would have you believe, I think, in some. Yellow. Oh, it's pink this time. I'm sorry about that. I'll have to get my yellow stack out for the next batch. Yeah, there you go. Oh, yes. All right. Also had no clue about pleading guilty. Has this one been appealed yet? Nope, not yet. Not yet, everybody. All right, well, next time we'll get the yellow going. All right, here we go, everyone. Here's the order on protective order over the pretrial discovery. Again, we're out of Georgia, and this is due to the leaking of the proffers that were given. On September 27th of 2023, the state requested entry of a protective order pursuant to Georgia Code Section 17-16-4, sub D, over all provided discovery materials to protect witnesses, confidential or sensitive information, and defendants' own rights to a fair trial. The following day, Defendant Schaefer filed a notice that he and 9 other defendants intended to begin negotiating with the state for a jointly proposed protective order. Now, I did not take you through Schaefer's motion because the judge's order came out so quick. So, 1 week later, Defendant Schaefer filed a second notice informing the court that the parties remained at an impasse and that the defendants intended to submit their own alternative version of a proposed protective order. However, the court never received any such proposal. Oh dear. Yikes. The order to order. On October 16th of 2023, after the court inquired about the matter in open court, the state and counsel for the defendant, Chesbrough, indicated that motions were not yet ready for a ruling. Now, the state has filed an emergency renewed motion for a protective order on November 14th, to which Defendant Schaefer responded in opposition that same day on behalf of himself, defendants Trump, Smith, Cheeley, Still, and Latham. And we have a footnote number 1 here. It says subsequently joined by defendants Clark, Roman, and Floyd. As subsequently noted, however, defendant Floyd later reversed his position and opposed the entry of any protective order during the hearing. So this is all over the place, everybody. This poor judge. Oh my goodness. It's all over the place. The court conducted a remote hearing on November 15th, and I will be live streaming that hearing in the future, during which the state and defendants Trump, Giuliani, Eastman, Meadows, Smith, Cheeley, Schaefer, Still, Cuddy, and Latham all announced that they consented to the entry of defendant Schaefer's proposed order. On the other hand, defendants Clark, Floyd, and Hampton opposed any order with varying levels of strenuousness. Defendants Lee and Roman did not appear. Finally, intervening counsel for several local and national media organizations voiced his objection to any protective order on First Amendment grounds. Having considered the dueling proposed protective orders, oh my gosh, the law and the argument of counsel, the court finds the entry of a protective order concerning pretrial discovery necessary and justified by the particular circumstances of this case. In Georgia law, the only explicit reference to protective orders for pretrial criminal discovery can be found in a rarely, if ever, appealed section of the Criminal Procedure Discovery Act. And he's citing it down here. So that's that footnote here, applicable to felony cases. Upon a sufficient showing that a discovery required by this article would create a substantial threat of physical or economic harm to a witness, the court may at any time order that the discovery or inspection be denied, restricted, or deferred, or make such other order as is appropriate. So again, that's the Georgia Code. And then here, outlining standards for protective orders in civil cases, Federal Rule of Criminal Procedure 16D sub 1. So just in case you're wondering where the law came from, if confined solely to this statute, a moving party or trial, just so you know, moving party is the one who files the first motion. That's what makes them moving. During court, would be left unable to consider the effect that pretrial disclosure of discovery materials has had on other important matters, such as trial preparation. I'm sorry, I'm double checking to make sure I'm in frame here, everybody. Hold on just a moment. There we go. I think I'm back in frame. Am I in frame, everyone? I got to double check on that. Great question. Where's the sticky note? Yep, it's right here. I'm double checking to make sure I'm in frame well enough, everyone. Perfect. Okay, thanks, Suze. Appreciate it. Okay, The court would be left unable to consider the effect that pretrial disclosure of discovery materials has on other important matters, such as trial preparation or the prospective jury pool. But the court finds that this section of the code is not the sole source of authority for the entry of a protective order. Every court has that broad power, quote, to control in the furtherance of justice the conduct of its officers and all other persons connected with a judicial proceeding before it in every matter appertaining thereto. And then he's citing a U.S. Supreme Court case out of 1984, finding regardless of any particular procedural rule, a court retains jurisdiction to enter a protective order, quote, under the inherent equitable powers of courts of law over their own process to prevent abuses, oppression, and injustices. Thus, setting aside whether the consenting parties have established a substantial threat of physical or economic harm to any particular witness, the court finds that additional concerns at play here justify the entry of a protective order. First, allowing parties the unfettered ability to share pretrial materials with the public undermines the smooth functioning of the discovery process. Discovery is designed to avoid unnecessary surprise at trial and level the playing field. A party may be tempted to delay disclosure or avoid reducing items to documentary form if the possibility of public vetting is ever present. Such a logistical roadblock was already demonstrated in this case when the state, in reaction to the public release of the recordings of recent proffers given by 4 defendants, indicated that all subsequently produced videos would only be viewable by defense counsel in person. So that was her reaction, was to say, if you want to see them, then you need to come to my office. Only with full and unimpeded discovery will a case as cumbersome as this ever stay on track and be ready for trial without inordinate delay. In addition, and more concerning, potential jurors should be limited from exposure to materials that may be deemed inadmissible at trial. One party may believe a piece of evidence should be considered by the public at large, while another finds it prejudicial and damaging to the jury pool. The court has an interest in ensuring that all parties retain their right to a fair trial before an unbiased jury, a process that could become unattainable should the public be allowed to vet every piece of unfiltered evidence months before trial, which is such an excellent point. Borrowing from the well-litigated principles highlighted at the federal level, the court also notes that the proposed protective order does not offend the First Amendment. Quote, discovery is neither a public process nor typically a matter of public record. Historically, discovery materials were not available to the public or the press, citing the Anderson case. Finding sealed discovery documents accompanying a motion were not a matter of public record. See also the Smith case, surveying array of federal case law applicable to protective orders. In addition, the proposed protective order exempts information gained from other sources and is more narrowly tailored than a blanket umbrella order covering all discovery. Here's footnote number 4. So we'll bump down here. Should circumstances require, this should not be read to foreclose the imposition of such a blanket order in the future via an amended protective order. So that's number 4. The likelihood of harm in this case is severe, as extensive media coverage guarantees broad dissemination of any disclosed discovery material. Finally, the order is not indefinite and will expire at the conclusion of the case. With these justifications in mind, the court hereby enters the attached protective order as proposed by Defendant Schaefer with slight modifications, effective immediately. So ordered the 16th day of November. So there you have it, everybody. There is his rationale, justification for needing that protective order. So that, I think, was very important. Now, let's get into the protective order itself here. Let me make sure I'm in frame again. I've got a couple different angles I'm working on, so that's why I have to just double check and make sure I'm in frame okay. I do have a little sticky note here that I do include just so everybody knows what the document is that I am reading through. here. So just so that you know, tea break. Yes, I will. I'm putting another paper clip on here. Here we go. This is my high-tech version, everybody. Oh my goodness. All right. So all right, let's get into this. Do you know what changes the judge actually made compared to the original protective order? So great question. I have his original proposed order here. So I do have that in here. At this point, I'll go through it and see. We can go through if you're interested, and we can pick out what's a little bit different. But here is his original, and then here is what the judge has decided. So we can pull that apart. It is green tea, actually, tonight. Green tea, yep, it is. It's chai green tea. Is that weird? I don't know. I'm enjoying it. All right, the protective order regarding all pretrial discovery in the indictment for this case. So the court enters this protective order concerning discovery material produced by the state to defendants. Number 1, this protective order does not apply to information or records that are publicly available, independent of the state's discovery productions, to the defendants. Information or records which the defendants or defense counsel came into possession by independent means, unrelated to the discovery process, or information or records which has been filed or received in evidence in any other court proceeding. That's number 1. Number 2, for the purposes of this protective order, sensitive materials shall mean any evidence within the state's discovery productions to the defendants and their counsel, which the state believes in good faith is entitled to confidential treatment under applicable law, and which the state designates as sensitive materials. So we need to have the label on there. The state shall review its discovery productions to the defendants or their counsel and shall specifically designate any evidence and the basis for the designation which the state believes in good faith constitutes sensitive materials in writing, served on the defendants or their counsel within 30 days of the date of this protective order. For each item of evidence which the state believes constitutes sensitive materials, the state shall state in writing, served on defendants or their counsel, the grounds on which the item of evidence is contended to constitute sensitive materials. So the state can label it as a sensitive material, but they do need to give justification for that. The state shall designate any evidence believed to constitute sensitive materials in all future productions of discovery to the defendants or their counsel at the time of production. The state shall physically label any and all documentary evidence designated as sensitive material in any future production with the legend sensitive, and shall label any other types of evidence designated as sensitive materials in any future productions with the word sensitive at the beginning of the file name. So this is how they're going to code things. The defendants and counsel shall have 14 days from production of any discovery designated as sensitive materials to notify the state that the defense contest the designation. If the parties are unable to come to an agreement on whether the discovery is appropriately designated as sensitive material and a motion is filed with the court, the defense shall continue to treat the disputed discovery as sensitive materials until the motion is ruled upon by the court. Oh, thank you. Oh my goodness. Lovely. Appreciate that. The defendants and their counsel and their counsel's co-counsel, employees, assistants, paralegals, consultants, agents, experts, or potential witnesses may use evidence designated by the state as sensitive materials solely in connection with the defense of this action and for no other purpose, and in connection with no other proceeding without further order of this court. This protective order is intended to allow the defendants and their counsel to the broadest and least restrictive use of evidence produced by the state to the defendants and their counsel, consistent with any good faith concerns by the state regarding sensitive information. The defendants and their counsel shall provide, let me just double check again, shall provide a copy of this protective order to any persons or entities to whom the defendants or their counsel disclose any evidence designated by the state as sensitive materials, and shall 1, requires such persons or entities to sign and date a copy of this protective order, and 2, retain such signed and dated copies for the inspection by the court. So they need to make sure anything labeled sensitive materials, they have seen the protective order and have signed it. The defendants and their counsel shall not otherwise disclose evidence designated by the state as sensitive materials to any persons or entities other than employees, assistants, paralegals, consultants, agents, experts, or potential witnesses connected to the defendant's defense of this action, or to counsel for other parties without further order from this court. The defendants and their counsel and their counsel's co-counsel, employees, assistants, paralegals, consultants, agents, experts shall keep any evidence designated by the state as sensitive materials in their custody and control. Any evidence designated by the state as sensitive materials shall not be filed with the court except under seal and shall not be introduced in any trial or hearing in this action without having redacted from the evidence any information required to be redacted from the filings pursuant to Georgia law. In addition to the information required to be redacted from the filings pursuant to this law, the parties shall redact any residential addresses, telephone numbers, and email addresses from any evidence designated by the state as sensitive materials from any evidence introduced in any trial or hearing in this action. This protective order does not alter, waive, modify, or abridge any right, privilege, or protection otherwise available to any party with respect to discovery. Any party may move for modification of this protective order. Inadvertent production of any evidence designated by the state as sensitive materials to any person or entity shall not alter, waive, modify, or abridge the status of the evidence as sensitive materials. In the event that evidence designated by the state as sensitive materials is inadvertently disclosed, the party that inadvertently disclosed the evidence shall give written notice of such inadvertent disclosure to the state within 7 days of the discovery of the inadvertent disclosure, and shall, 1, take all reasonable efforts to cause the person or entity to whom the sensitive materials were disclosed to return or destroy the sensitive materials and any copies thereof, and 2, request such persons or entities to sign and date a copy of this protective order and retain such copies for inspection by the court, whether signed and dated or not. Within 30 days following the conclusion of this action or any appeal of this action or any collateral challenge to this action, the defendants and their counsel shall destroy all evidence designated by the state as sensitive materials and any copies thereof. So ordered this 16th day of November by Judge Scott McAfee. So there we go. That is the protective order that was put into place because the proffers were leaked to the media. All right. So there is that. Next up, out of Georgia then, let's take a look at Ms. Fani's motion regarding setting trial. So that's the next one here. That's it. That's it for the order. Yeah, that's it. That's it. We love Judge. We do love him. He's setting him up, knocking him down. He's not. He doesn't have time for any funny business in his court. Oh, all right. Let me just make sure here. I've got everything I need. So before I dive into her motion here, I do have, if anyone is interested, I could go through, not in my court exactly. So we do have a motion that was filed by Mr. Trump regarding this discovery issue. So let me take you through this. It's only about 3 paragraphs here. I'm not going to put a sticky note on this because it's just literally 1 page here. But he did subsequently file this motion later. So it's unique. So we'll go ahead and go through it. One or more leak. There was one. It was Misty Hampton who said that it was. What do you mean? Nope, just Mr. Trump. Yeah, Mr. Trump. Motion to obtain access to relevant discovery materials in the District of Columbia, federal criminal case and request for a hearing. This motion is ridiculous. I'm going to tell you that right now. This is an example of something that does not happen. This is completely off the wall. So here we go. Prepare for the baloney. President Trump moves the court for a hearing to discuss reasonable and efficient means to obtain access to relevant discovery material disclosed by special counsel Jack Smith's office. This is for the Georgia case, everybody. All right. The prosecutors in the D.C. case to President Trump's counsel of record, D.C. counsel, for the rationale noted in the attached email. Undersigned lead counsel Steve Sato has attempted informally to obtain the discovery letters and itemized list of discovery material disclosed to D.C. counsel. Here. D.C. counsel has responded that the protective order in the D.C. case prevents disclosure of the requested discovery letters and itemized lists. So let's flip. As Exhibit 1 makes clear, President Trump is not currently seeking access to the actual D.C. discovery material. Instead, he's seeking a practicable way to determine if any discovery material disclosed in the D.C. case is arguably relevant in our case, in Georgia, relating to witnesses the DA's office may call at trial or bearing on factual issues raised by the charges in the indictment likely to be in dispute at trial. Can Trump get any more irrelevant? That's a great question. As a starting point to obtain access to D.C. relevant discovery materials. So he's asking the judge, the Georgia judge, Judge McAfee, to contact D.C. so that he can get discovery material in D.C. See how interesting this is? President Trump suggests to the court and the DA's office the following means to seek the disclosure of the requested discovery letters and itemized list of discovery. Number one, the DA's office, so this is Fani's office, contacts the SCO to determine if the SCO will disclose the letters. So special counsel's office out of D.C. So Fani needs to contact Jack and see if Jack will disclose the letters and list to Fani now that a protective order has been entered in the case. That's the first request. Number two, the court contacts the district court in the D.C. case to determine if suitable arrangements can be made to disclose the letters and list to this court for disclosure to Fani's offices and President Trump's undersigned defense counsel. So now he's asking the court to call the court in order to make arrangements for these letters, all right? Number three, the court authorizes President Trump to issue subpoenas, ducis tecum, which means production, so production of documents, to the special counsel's office and D.C. counsel for the letters and lists. So now he's asking the court to authorize Trump to be able to go to the D.C. case and subpoena this information out of the D.C. case, of which, of course, the judge has no jurisdiction. Wherefore, President Trump respectfully requests the court hold a hearing on this motion, and if possible, that this motion be added to the December 1st, 2023 agenda. So, again, that's just a glimpse. I'm not going to spend too much time on it because it's ridiculous, but had to share. This is absolutely not the mechanism if you want to try to get discovery out of another jurisdiction. Like, this doesn't happen. This is, stupid, I think is a good word for it. So there we go. Do my homework for me. Oh my gosh, that's exactly right. Oh, all right. So there we go. So many things about today's hearing that I want to know. Yes, absolutely. I will be going through that hearing. I will do a full live on that. I can't pay my lawyers. You call. That's funny. Yeah, it's a lot. It's quite a bit. It's quite a bit. I have never seen anything like that before. Hey, judge, do you mind calling the other court? Like, what? All right. So next up, we've got Miss Willis's motion for a trial date. So let me write that out here. This is the Georgia case again. Georgia case. And then we have the DA's motion for a trial date. So let's get into that. Trial date for August 5th. All right, there's enough baloney. Appealing the Colorado verdict. I haven't seen any of that yet. We just went through the Colorado decision yesterday, so I'm kind of giving that a little bit of time to cook. I'm giving that a little time to percolate. So that will be absolutely, I have no doubt there will be appealing going on with that, and we'll be following that for sure. But I'm kind of letting that simmer a bit. All right, 1 minute here while I address my sticky note situation. Oh my gosh. I know you are all here for the very high quality performance of my sticky note with my paper clips. Oh my goodness. My birthday. I hope good news happens. Well, yes. Happy birthday. Oh my goodness. All right, here we go, everybody. So this was filed just on Friday. Here we've got looking forward to the Georgia judge's response to this request to get access to the DC stuff. I agree. It'll be very interesting because Judge McCaffey's like, all right, what are you guys going to say? Now let's keep it moving. All right. Tomorrow's yours. Oh, happy birthday. Wow. Okay. Love that. Love that. State's motion to schedule trial date for August 5th. Do people appeal rulings just because they dislike the outcome? Yes, they do. And for all of these cases, everything is going to be appealed all the time, all day, every day, appeals forever, forever and ever and ever is what's going to happen in all of these cases. I have no doubt whatsoever. So... All right, comes now. The state of Georgia, by-in through Fulton County District Attorney Fani Willis, moves this court to schedule the trial for the remaining defendants to August 5th of 2024. The state requests that this court schedule the remaining defendants for a final plea hearing date of Friday, June 21st of 2024, and to begin trial on Monday, August 5th of 2024. This proposed trial date balances potential delays from defendant Trump's other criminal trials in sister sovereigns and the other defendants' constitutional speedy trial rights. Currently, defendant Trump is set for trial in the District of Columbia on March 4th and in the Southern District of Florida on May 20th. The start date, oh, she didn't put the New York case in. That's interesting. A start date of August 4th or of August 5th of 2024 is therefore unlikely to be subject to delay or interference from these other trials. Additionally, setting trial to begin on August 5th of 2024 would begin trial within 1 year of August 14th of 2023. Let me make sure again I'm in frame, everybody here. The date of indictment, and would show deference for each defendant's constitutional speedy trial rights. So let's bump down to footnote number 1. Generally, after 1 year, the delay is presumed to be prejudicial and triggers a Barker inquiry. However, the Georgia Supreme Court in the Ruffin case indicated that such a presumption would attach after a longer period for cases involving crimes with unusual complexities, such as the allegations of a vast interstate conspiracy or the involvement of a sophisticated crime syndicate. To take but one example, the delay that can be tolerated for an ordinary street crime is considerably less than for a serious, complex conspiracy charge. So that is pretty T-break. That's a pretty standard procedure. We try to always bring cases within a year, but there are, of course, exceptions. All right. August 5th of 2024 trial date would balance these two scheduling concerns. In accordance with this court's standing case management order for criminal cases, the state also requests the final plea date be set for June 21st of 2024. The state will entertain negotiated guilty pleas up until the final plea date. After the final plea date, the defendants will only have the option of non-negotiated pleas. Ooh, that's interesting. That's interesting. Okay. So she's saying that after this date, she's not going to negotiate the pleas. She's just going to tell you what you can get if you want to plead. Very interesting. And the state intends to recommend maximum sentences at any remaining sentencing hearings. Whoo, goodness. Yikes. Yikes. Moreover, the state requests this court to not consider any severance issues until after the final plea date. In the current procedural posture, the laws favor keeping the remaining defendants together for trial. So that is something Judge McAfee has mentioned before about this idea that he had of breaking up this final batch of defendants possibly into 2 more trials. So at least 2 trials. So I think that's what she's trying to address here. Speak now or forever hold your peace. Yes, speak now or we're not going to negotiate. All the power then shifts back to the state if they miss that date. All right, so we're citing case law. It would impair both the efficacy and the fairness of the criminal justice system to require in all these cases of joint crimes where incriminating statements exist that prosecutors bring separate proceedings, presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have the advantage of knowing the prosecution's case beforehand. So that's an excellent citation. The RICO conspiracy charge ensures any trial would share the same evidence and witnesses. In a case where the same witnesses, the same evidence, and the same charges would be used against all defendants, thus affecting judicial economy in the use of physical facilities and the time of witnesses, jurors, and court personnel. The trial court must consider these efficacies against the possible conflicting interests of joint or multiple defendants, citing a Montgomery case here. Additionally, there have been guilty pleas from 4 defendants already, and more defendants could choose to enter guilty pleas in the future. Waiting to rule until after the final plea date would place this court in an optimal position to adjudicate any severance claims, including, quote, the likelihood of confusion of the evidence and law, the possibility that evidence against one defendant may be considered against another defendant, and the presence of antagonistic defenses. Antagonistic defenses are defenses that conflict with each other. So if you've got multiple defendants and they have defenses that are in opposition of each other, that's what we're talking about there. Once there's better clarity on which defendants remain for trial. So that's a really excellent point that she's got. Finally, the state has experience and resources to try multiple defendants together in the Atlanta Public Schools trial here, State of Georgia v. Coleman. 12 defendants, is it Coleman? Cotman. 12 defendants were tried simultaneously and effectively. The Georgia Court of Appeals found that the trial court did not abuse its discretion when it denied a severance motion brought by defendant Evans. Citing case law here again. No issues about severance raised on appeal. Evans's complaints about the length of the trial, the number of defendants, and an evidentiary dispute with co-defendants did not rise to a denial of due process that required severance. So again, she's trying to address this issue that the judge had spoken earlier about, available for use in the upcoming trial in this case. The state clearly retains the logistical and prosecutorial capabilities to try all of the remaining defendants together. And we'll flip one more here. Oh, we're lagging. Are we getting reported, everybody? Are we getting reported? Yikes. Oh my gosh. Yes, this is the time in the live where I say if for some reason, if I do get booted, I do move over to my Tube of You channel, which is under the same name, just in case. So yes, I will pop over there if that happens. Hopefully that won't, but we just never know anymore. All right, so let me jump back in. All right, so trial for all the remaining defendants should be set for August 5th, 2024, as that date balances potential delays from other pending criminal trials with the defendants' speedy trial rights. Further, no severance motion should be considered until after the final plea hearing date, as the court will be in best possible position to adjudicate any severance claims at that time. For the reasons set forth above, the state respectfully requests that this motion be granted, with its court setting a final plea hearing date for Friday, June 21st, and trial for August 5th. Respectfully submitted the 17th day of November. So she has requested that August 5th trial date. We will see what happens with the judge, if the judge agrees or not. So I think she makes a valid argument. All right, everybody. So that's the update out of Georgia. Again, a friendly reminder, I will be doing a couple of lives going through the bond revocation hearing as well as the protective order hearing in the future. So let's move on then to the DC case. Okay, so let me get myself sorted out. Here is the DC case. We do have a few motions here. How long does it take to write a document like this? Oh, this one, I don't know. I would say because of proper citations that she's got going on in here and case law that she needed to cite, I don't know. She would probably already have this case law pulled, so I don't know, a couple hours. I mean, it'd take a few days to think about it, and then to sit down and write it probably takes less time. Everybody's a little bit different, but that's how I do my legal writing, is that I do a ton of research and then I just think about it. I have to kind of, walk around, chew on it, think about it, and then when I'm ready, I can sit down and just write it at the time. So that's usually how a lot of the writing will work. And we're kind of trained to do that from going through the process of taking law school finals. So that's one of the ways they teach us. All right, everybody. So let's get into the DC case. We've got several different things going on here. We have President Trump's reply in support of a motion to stay here. I'm not actually going to go through this order. I'm just showing you what it is, but I'm not going to take you all the way through this order. Or through this motion, but he did put a reply in, and that was on the 15th. I will be going through the opinion and order here, though. This is where it gets really interesting. We have this, the defendant filed a motion to strike the inflammatory allegations from the indictment. So if you remember, he filed a motion stating any reference to January 6th and him should be struck from the indictment. He also did an unopposed motion for an extension of time to file opposition. So I will go through that one as well. We have, that's Florida. Hold on a minute. That's the SIPA one. We've got another order then here out of the District of Columbia, and then the reply in support again. So I've got 2 copies of the reply in support of that strike. So we'll go through that. Should be Donald Trump, not President Trump. So here's the deal. Anytime you see the highlight in orange, it means it's filed by Trump's team. So all of his motions, all of their filings have him listed as President Trump. Any of the government's filings will have him listed as Defendant Trump or just Trump. Even the court orders themselves lists defendants' motions, and so on. So if you see President Trump listed in the title of a motion, it's because they were filed by his attorneys. All right, just so you know. Just so's you knows. All right, so let's take a minute then and just briefly review the DC case. So here is the indictment out of DC. This is being presided over by Judge Chutkan here. Yep, absolutely. Yeah, it's kind of, it's unusual. If you're not familiar with the paperwork, then it would be, it does seem kind of odd, doesn't it? So here's the indictment out of DC. Now remember, this indictment is unique because he is the only defendant. We have 4 counts that have been charged. Count 1, which is conspiracy to defraud the United States. Count 2, which is conspiracy to obstruct the official proceeding. Count 3, which is obstruction of an attempt to obstruct an official proceeding. So that was the, had to put Congress on pause for a while. And then the 4th count is conspiracy against rights. And this was conspiracy against voting rights. So with these counts, I think it's very interesting to note this will probably be the case where that Colorado opinion will play the biggest role because there were so many findings in her ruling. So I think that will be helpful in kind of devising a strategy for this case. they can't submit her ruling into court. Things just don't work that way, but they can definitely see strategically how things what helped the judge come to her decision in that case and use that. So yes, we're not really looking at a particularly large amount of prison time here. This DC case is more about the content. It's more about this conspiracy, the defrauding, and the conspiracy against rights. So the most prison time is in the Florida case because there are so many counts with the classified documents. The mandatory prison time is in Georgia. So that's kind of how these break apart. So this has the most significant effect overall of the actions that were done, but not via prison, but by the severity of the charges themselves. All right, so that's kind of the update here on that indictment. So let's get into some of these motions here. Now, there was a barrage of motions that he had filed all at once, and so there have been a whole bunch. What's the most prison time for the DC case? I would assume for each one of those charges, and they would probably run concurrently. I mean, I don't think we're looking at more than 5 to 10 years. Does he have a jury trial in Georgia? Yes. He's a jury trial in all of his cases, in all of the criminal cases. Yep, the only jury trial that he didn't have was his New York civil case, and that's because it's actually uncertain under New York law if a jury would even be allowed, and a jury wasn't requested. So it was kind of a twofer in that particular situation. So let's go through his reply in support of his motion to strike. So this is, again, a very interesting here, and it kind of takes us back to what the Colorado judge was talking about. Because the next order that was issued goes into this motion to strike, I think it's important to have a little bit more background on it. All right, so here we go. So we'll go through this one first, and then I do have this order, and then we'll kind of do a brief update after that. Let me get my sticky note ready here for this one. Make sure I'm in frame, everybody. There we go. Hello, welcome everybody. Anyone who's new. Will the judge's treatment of Trump's documents case be scrutinized by a judicial panel? I don't think so. And not at this point. I can't see what the mechanism for that would be. You can appeal any of the decisions, and then the appellate court can come back and make the decision if it's an interlocutory appeal. So there is an appellate process. You can appeal any judge's decision when you're going through it. All right, let me make sure I've got a sticky note here. So this is the DC case. I'm just writing this out, and this is Trump's reply and his support of motion to strike. Again, I'm setting this up so that you'll know where the order is coming from. Can I ask a question? Of course, Hazel. I don't think Trump really knows that he already lost the New York fraud case. I don't think he knows either, Jim. I don't think he knows either. I think he's confused. I'm not sure winning is the same thing for him as it is for other people. In my opinion, that's what I think. But unprecedented, absolutely. Yeah, it really was. Absolutely. Support. Okay, reply in support of motion to strike. You should use a Sharpie. Yes, I used a Sharpie before. Yes, I kind of go back and forth. It depends. It seems like whichever I choose, it's not going to be quite right. Can any of these cases stop him from running? No. No, there is no mechanism to stop him from running at all. I know we're trying to get there with the 14th Amendment, Section 3, but that's a long shot to have that done in time for the election. So no, there is nothing preventing him from being on the ballot. There is nothing that's going to keep him off of the ballot. So I think unless he loses the Republican primary, the key is whoever comes out of the Republican primary. If he loses in the primary, he will not be on the ballot. If he wins in the primary, he will be on the ballot. Who's working on Amendment 4? Yes, there's lots. There's a lot of things going on, but I still don't think that piece, the 14th Amendment, that case is not going to be decided in time. It will not be decided in time. If you are wanting him to be shut out from being on the ballot from the 14th Amendment, it's not going to happen in time, everybody. It's just not. That's just being realistic. Eventually, it could come out that he is disqualified under the 14th Amendment, that he should not be on the ballot, but it's not going to be done in time. So I think that's something to kind of start wrapping your mind around. When's the vote to see if he's on the ballot? Well, Colorado was really the best shot at this point, and Colorado has already determined he is on the ballot. So I think it's fair to say at this point, even through the appellate process, we're turning a corner. We don't have much time left before things start happening. So let me just give you a little perspective here. This is a Republican primary. He'll try as an independent. He could try as an independent, I suppose, if there isn't another independent. But let me just show you where we're at, everybody. So we have right now, right, we're here. We're in this area. We've got motions to compel status conference coming up. We've got a few more updates, 11th Circuit appeal going on. Then we have the holidays coming into play. Flip the page, and before you know it, it's the Iowa caucuses. We're too close. We're too close to the election, everybody. And the way that our courts work at this point, it's just too close. It's too close to call that this will be put into place by the time the ballots are sent out to be voted on. We've got the Iowa caucuses coming up, and then again, before you know it, we've got Super Tuesday, and that's right after the DC case starts. So here's my prediction, and this is just my humble prediction. I hate how early we vote in Iowa. Well, it's early. Yeah, you guys aren't playing around. But here's the deal. All of this preventative measure in order to keep him off the ballot, I think, is an excellent point and constitutional law question that needs to be answered. But I do not believe it will be decided before the election occurs. It will not be a preventative measure. It's going to be a clarification of the Constitution. All right. I think truly, legally, from a legal perspective, we will get clarification, but this will not be the preventative measure. After all the cases, I know, Jilly Bean, I know it's a lot, but I don't want to, put any false hopes out there, everybody. When we're talking about the 14th Amendment, we're talking about a huge constitutional law question, and that question needs to be answered, and it's important. It's important to go through the cases and go through the issues and ask the questions. Insurrection, engagement, was the oath good? Was he an officer? All of those questions are very, very valid questions, but ultimately, in the end, the time has run. It's not going to be an issue of getting him off of the ballot. It's an issue of how the Constitution applies. All right. So I think if Colorado had set the precedent and told the Secretary of State to keep him off of the ballot, I think it would be possible. But because of the ruling, I do not believe that it will be. He doesn't have to be on the ballot. If he is not elected in the primary, you should use a laminate card and use. And I hate to be the one to be the bearer of bad news here, but I think that reality moment is really here. Just agreed to take up the appeal. Yes, and I don't doubt it. And we will start to see the process go here. But in all reality, the timing is up. I think the timing is absolutely up. So, okay, motion to reply in support of his support motion to strikes. Let me just get this last bit in. And again, I'm telling you that this, not for any kind of fear issue. I'm just saying, this legally, this is just kind of the reality of it. This is just where we're at right now in the legal process. So I think the Civil War issue, if that would have happened, that would have been on January 6th. I think that's the closest that we came. I think that has passed. I think the time for that has passed. Now, whether or not we come out with a full democracy, after this next election? I think that'll be a great question. But this is your life. Please do and use implements of your choice. Absolutely. Oh, absolutely. Oh, it's lagging. Oh no. Oh no. That's all right. That's all right. We'll keep it moving. We'll keep it moving, everybody. So now I'm not trying again. I have my own personal understanding and my political science background, and I have to say this: an incumbent president has a huge chance of winning re-election. Now, let me just remind you, there are not very many one-term presidents out there, and there's only one president that had a space in between his presidencies, and that was Grover Cleveland. So if you look at it historically, it's a very interesting place to be in history. So I'm not pessimistic. I'm still very optimistic at this point. All right, so let's kind of dive in here and get through what this reply is about. So let me give you a little bit of the backstory out of the DC case. He had filed a motion against the indictment. So anything referring to January 6th would be struck from the indictment. So that he was saying it was too inflammatory, it was too prejudicial. All right. So the government filed a response saying the facts are the facts. This is his response to the government's response. So we would call this the reply. So there's three movements. There's the motion, the response, and then the reply. This is the reply. So he puts this in, and then we have the order that directly follows it. All right. Let's get into it. Again, this is filed by him. Let me make sure I'm in frame, everybody. Quincy Adams did, or his son. Yes, they were cousins, I believe, weren't they? I'm not sure. That's good. The Adams situations, I should look into. Yeah, I've forgotten now. All right, here we go. The prosecution falsely asserts that President Trump is responsible for the events at the Capitol on January 6th. However, the indictment does not charge President Trump with causing or participating in those events, nor could it, as not a shred of evidence suggests President Trump called for any violence or asked anyone to enter the Capitol unlawfully. Again, I think it's important to go through this after going through the Colorado decision that came out. In fact, President Trump clearly and repeatedly called for peaceful and patriotic assembly consistent with the finest ideals of our country. President Trump also authorized over 10,000 National Guard troops to prevent violence on January 6th. By the way, this is false. That is absolutely a false statement. So I'm just going to clarify that. Legally, that is a false statement. Protection that was denied by Democrat Speaker of the House Nancy Pelosi and Democrat Mayor of Washington, D.C. Muriel Bowser. This is also false. That is a clearly false statement as well. Thus, even these transparently partisan prosecutors could not obtain an indictment on that basis. The prosecution now seeks to try President Trump for crimes the grand jury never charged, based on actions President Trump did not take in a place he never was on January 6th. Is perjury by a lawyer punishable? It's hard to prove. It's hard to prove perjury. The lawyer could truly believe what he's saying, and if he truly believes it, then it's not perjury, even if it's completely false. By people he never directed, and opposite to actions he actually did take and statements he made, all with the goal of inflaming and prejudicing the jury. The prosecution may not do so. Allegations that third parties allegedly acted improperly, again, I'm trying to make sure I'm in frame, everybody, will serve only to inflame and prejudice the jury and do not belong in the indictment against President Trump. The court should strike them. Here we go, number one. My opinion might be wrong. Absolutely. I'm open to that, but it's still my opinion. President Trump also intends to move in limine to preclude evidence relating to the challenged allegations. The prosecution's opposition has previewed at least one basis for that motion, should it be necessary. For instance, the prosecution claims protesters were extraordinarily violent and destructive. Even if marginally relevant, which it is emphatically not, the danger of unfair prejudice, confusing the issues, or misleading the jury would far outweigh any probative value. And this is Federal Rule of Evidence 403. which is such an annoying objection. It's a valid objection, but it's annoying. The fact that the prosecution even suggests that such inflammatory claims could have an appropriate place in the trial of President Trump only underscores the unfair and malicious way the special counsel is pursuing this case on behalf of the Biden administration against its leading political opponent, President Trump. Yikes. Again, that's... Oh, my gosh. All right, here's the background. Are we ready, everybody? Are we ready? Should I get the red pen out? I don't know. I don't want to get the red pen out. All right, January 6th of 2021, here we go. President Trump spoke to a crowd of peaceful supporters gathered at the White House Ellipse, about 2 miles from the Capitol. During his speech, President Trump acknowledged that after he was finished speaking, some of the members of the crowd would walk to the Capitol to cheer on our brave senators and congressmen and women and peacefully and patriotically make their voices heard. Need more bread. Mark it up for sure. Oh my goodness. Oh my gosh. Oh my goodness. All right, here we go. All right. Now, I'm not going to read directly from his speech because I've gone through his speech multiple times, but there's direct quotes there from the speech. It's just too inflammatory to read out loud. Oh my gosh, this is fiction. So it feels like it sometimes. President Trump made clear what he expected, that he expected the electoral certification proceedings to take place with the vice president and every congressperson and senator exercising their duties of their offices as the Constitution provides. I don't understand how his attorneys can get away with writing blatant lies in a court filing. You know, it's a good point, but you know, we're zealously advocating. There's no excuse for it other than to say, you know, we kind of just do what we need to do. So that's how it's going. Rose-colored glasses. I'm not sure. I'm not sure. All right. President Trump also repeatedly opposed destruction of the monuments and other symbols of American democracy, and he referenced stiff criminal penalties for doing so, which he had signed into law. So I need to read this one because I'm not sure here what they're talking about. He said he repeatedly opposed the destruction of monuments and other symbols of democracy. Oh, thank you. And referenced stiff criminal penalties. And don't worry, we will not take the name off the Washington Monument. We will not cancel culture. You know, they wanted to get rid of the Jefferson Memorial. Either take it down or just put somebody else in there. I don't think that's going to happen. It damn well better not. Although with this administration, if this happens, it could happen. You'll see some really bad things happen. What? How is that him against destruction of monuments? What? Okay, so again, I'm reading this here so that we can get some kind of support. They'll knock out Lincoln too, by the way. They've been taking his statue down. But then we signed a little law. You hurt our monuments, you hurt our heroes, you go to jail for 10 years and everything. The country's future. Oh my goodness. Oh my goodness. As this enormous crowd shows, we have truth and justice on our side. We have a deep and enduring love for America in our hearts. We love our country. We have overwhelming pride in this great country, and we have it deep in our souls. Together, we are determined to defend and preserve government of the people, by the people, and for the people. Our brighter days are before us. Our greatest achievements still away. What? I've read his speech multiple times, and I'm not sure about that. Oh, my gosh. All right, so here's his support again. He's trying to get any reference to January 6th removed from the indictment. That's what this reply is, all right? The Secret Service and the FBI estimated that at least 120,000 Americans gathered on the Mall for the president's speech. Government agencies estimated about 1,200 people. At most 1% of the size of the crowd gathered to listen to President Trump entered the Capitol, and a smaller percentage than that committed violent acts. So 1% of the crowd, apparently. And then he's citing down here, the facts seem to indicate that as few as 1% of the people who were there fit the label of insurrectionist. Thus, we can easily conclude that the well over 99% of the attendees of President Trump's speech did not engage in the events at the Capitol. 99%, that's interesting. Is this Trump math? No. Moreover, as the indictment recognizes, a crowd had gathered at the Capitol before President Trump finished speaking, further proving that he had nothing to do with those events. All right. Recognizing a large crowd would be attending his speech, President Trump sought in advance to have law enforcement fully engaged and to mobilize the National Guard to ensure a safe event. No, this is false. That is false information. Footnote 8. A review of the DOD's role here, and we are citing Department of Defense Inspector General here, defense.gov. So we're citing that. Where'd they get those numbers? Great question. I think they might have found them in the elevator shaft in New York. According to General Mark Milley's testimony to the Department of Defense's Inspector General, President Trump made the request for military presence 3 days before January 6th. Mr. Miller and General Alternative Math met with the president at the White House at 5:30. The primary topic they discussed was unrelated to the scheduled rally. The general told us that at the end of the meeting, the president told him that there'd be a large number of protesters on January 6th. Mr. Miller should ensure sufficient National Guard or soldiers would be there to make sure it was a safe event. The general told us, Mr. Miller responded, "We've got a plan. We've got it covered." Okay. All right. Retired U.S. Attorney Lieutenant General Keith Kellogg confirmed General Milley's testimony. According to General Kellogg, on 3 Jan, the president asked the Defense Department to deploy National Guard's troops to D.C. for J6 contingencies. All right. President Trump's efforts to ensure full security were resisted by the mayor. So let's get into this pile of bologna sandwiches of the District of Columbia. Democrat Speaker of the House, Nancy Pelosi, and other Democratic congressional leadership. Now, we know this is incorrect, everybody. And Nancy Pelosi specifically came out and said absolutely nobody discussed National Guard with her whatsoever. They have twisted the facts quite a bit, and even in a legal filing. Despite exhaustive investigation, the FBI found no evidence that President Trump was responsible for the actions at the Capitol on January 6th. Just the opposite. After 7 months of investigation, the report revealed the FBI has so far found no evidence that President Trump or people directly around him were involved in organizing the violence, which we know is a complete contrast to what the judge in Colorado found. Footnote number 12. Here, FBI finds scant evidence, and this is a Reuters article being cited. After investigating for more than 1 year, including by interviewing thousands of individuals and collecting hundreds of thousands of phone calls, text messages, social media postings, and other documents, footnote number 13, and this is an article by Newsweek. The FBI found no evidence connecting President Trump to the actions at the Capitol on January 6th, which is number 14, and we are citing the Washington Post. FBI resisted opening a probe into Trump's role into January 6th for more than a year. That's the citation. Despite many breathless stories about conversations, text, and secret meetings blaming President Trump for the events on January 6th, there was simply no evidence to be found. Footnote 15 here. Donald Trump didn't run the January 6th riot, so what happened? And this is another Newsweek article. All right. Nonetheless, in April of 2022, President Biden directed the Department of Justice to prosecute his leading opponent for the presidency through a calculated leak to the New York Times by more than a dozen of his aides and allies. That is absolutely, oh my gosh. So, oh my gosh, that's wrong. You don't know who leaked what to the New York Times. Oh my gosh. All right, so the Attorney General's deliberative approach has come to frustrate Democratic allies of the White House, and at times President Joe Biden himself. As recently as late last year, Biden's confided to his inner circle that he believed former President Donald Trump was a threat to democracy and should be prosecuted, according to two people familiar with his comments. Biden has said privately that he wanted Garland to act less like a ponderous judge and more like a prosecutor who's willing to take decisive action over the events of January 6th. This article is based on interviews with more than a dozen people, including officials in the Biden administration and people with knowledge of the president's thinking, all of whom asked for anonymity to discuss private conversations. So they're talking about what Biden is thinking under anonymous conditions. All right. Within days of President Biden's directive, I would not say that's a directive, to the Department of Justice, the FBI opened an investigation into the elector scheme that ultimately resulted in this indictment. All right. Here's argument number one. Let's see what he's got to say. Number one, references to actions at the Capitol on January 6th are not relevant to any charges against President Trump. All right. Language in the indictment may be stricken if it's not relevant and is prejudicial and inflammatory. Citing case law here, striking references to insider trading because the references are highly prejudicial to defendants because they reference a current hot topic in U.S. law that the defendants are not even charged with in this case. Citing another case law here. The indictment does not, flip the page, charge President Trump with insurrection, incitement, or any other charge relating to actions at the Capitol on January 6th, or any other charge. Wait, hold on a minute. Let's just, okay, so we have obstruction of an official proceeding that was occurring on January 6th, right? And an attempt of an obstruction of an official proceeding. Okay, so we have a couple of things. Tea break. So other charges. There are other charges. It's very interesting. Interesting. All right. So, relating to the actions on the Capitol January 6th. Oh, thank you. The prosecution admits this fact. That's incorrect. All right. Time for the red pen, everybody. Pen comes out. That's wrong. The prosecution has also conceded elsewhere that none of the charges against President Trump include an element of an incitement offense. The prosecution admits this fact. What? Oh my gosh, Sarah. Oh my gosh. None of the offenses charged here has an element, any of the required elements for the incitement offense. The elements of the charged offenses: defeating a federal government function through deceit under Section 371, obstruction of an official proceeding under Section 1512, and deprivation of rights under Section 241 are nowhere to be found in the elements of a violation of Section 2383. Do they realize that this was all live? I don't think so, Deborah. I don't think they do. Or any other potential incitement offense. All right. The prosecution has thus admitted that the incitement allegations littered throughout its opposition to the motion to strike are not relevant to any of the charges brought against President Trump. So that's wrong. Nor has the prosecution explained how allegations regarding the January 6th protest are relevant to the elements of the charges that it chose to bring. Oh my gosh. Indeed, the January 6th case relied on by the prosecution does not support its contention that the actions at the Capitol are relevant and probative evidence of the charged conduct. Several of the cases did not involve any of the charges brought against President Trump, rendering any relevance analysis inapplicable in this case. And we're citing case law here. Those cases did include at least one charge brought against President Trump, as well as charges not brought against him. All involved defendants who were personally present at the Capitol. Those are the types of cases the Attorney General specifically carved out of the special counsel's authority in this order. The authorization does not apply to future investigations and prosecutions of individuals for offenses they committed while physically present on the Capitol grounds on January 6th. Actual presence has been emphasized as an important factor in the relevant analysis. All right. Meanwhile, the prosecution's false assertion that President Trump is somehow responsible for the events at the Capitol on January 6th and that, quote, that day was a culmination of President Trump's criminal conspiracies to overturn the legitimate results of this is contradicted by the position taken by the Department of Justice in countless prosecutions of protesters who were present at the Capitol on January 6th. That's interesting. Wow, it's just fascinating how the mind is working here. Okay, consider, for example, the prosecution of Dustin Thompson. In its cross-examination of Mr. Thompson, who testified in his own defense, the government emphasized that Mr. Thompson's actions on January 6th were his own and not caused by anything President Trump had done. So let me go through this. So here's the question. Now, you mentioned that you had, before January 6th, listened to previous rallies of the president's, right? I have. After you listened to those other Trump rallies, did you go commit any crimes? I wasn't attending any of those, but no. Okay, so the answer's no. You didn't go commit other crimes. Correct. Notwithstanding, the former President Trump was very passionate during those speeches, right? Yes. He said a lot about how this was being this at those speeches, didn't he? He did. I was like, what is happening? And again, when the former president, referred to this during that time, you didn't go do anything about it, right? I wasn't asked to. He didn't make any suggestions at that time on what to do about the situation, just that he wasn't going to concede and that he was going to fight it. Okay. So you heard all those things before January 6th, right? Correct. When you heard it on January 6th, none of it was new? None of what was new? That he wasn't going to concede. You already heard that before that day, right? Yes. And you'd already heard that that he said that this was going to be stolen or had been stolen. Yeah, this is the last ditch effort. This is the way I looked at it. So the answer is yes. You had heard that before January 6th? Yes. None of that was new to you on the morning of January 6th? No, I was aware of it. Oh my gosh. Yikes. The government then proceeded to remind the jury that President Trump did not cause Mr. Thompson to commit the crimes with which he had been charged. Quote, and President Trump wasn't there standing right next to you, was he? Quote, President Trump didn't force you to go to the Capitol. He didn't force you to walk every step of the way to the Capitol building, did he? Quote, and President Trump wasn't standing next to you at the doors to the Capitol, forcing you to go inside, was he? Yikes. Quote, you'd agree with me that not once during that hour-long speech did President Trump say it's now legal to steal from the United States Capitol building. In the government's summation at trial, it specifically argued that President Trump's conduct leading up to January 6th was irrelevant. It is essentially irrelevant, in this case, what you think about President Trump's conduct that day, which doesn't have much context. I'm not sure. I would probably take points off for that. Need a proper citation. Moreover, the government asserted, quote, President Trump didn't hold his hand as he walked down to the Capitol to loot and defile the Senate's parliamentarian office when he stole those things. Like Manson didn't. Oh my gosh. That's another example. Take the government's prosecution of the Oath Keepers founder, Stewart Rhodes, for seditious conspiracy. According to the indictment returned against Mr. Rhodes, he allegedly led this group before, during, and after January 6th without any involvement or prompting from President Trump. And then they're citing that superseding indictment. Yes, hand-holding. Specifically, at Mr. Rhodes' detention hearing, the court asked the government, is it the government's contention that had there not been a mob of people at the Capitol that day, the Ellipse rally had simply ended, there hadn't been a mob that marched down to the Capitol, would this group of individuals led by Mr. Rhodes still intend to try and enter the Capitol building, even without a mob present? In response to which the government represented, Your Honor, the evidence is that they talked about the need to go to the Capitol grounds. So this doesn't even make sense. So I'm taking points off for that. Points. The defendant also made clear in the same message that President Trump must know that if he fails to act, we will. He has to understand that we will have no choice. So there is clearly, again, just to make sure that we're hand holding, isn't that sweet? Let's just make sure we're getting these quotes in correctly, all right? So we don't want to take them out of context because that would be bad. So there were clearly messages that we have directly from the phone evidence that show an intent to be on the Capitol grounds, an intent to make those in Congress uncomfortable, and an intent to fight to stop the result with or without somebody like President Trump calling them into action. And we think it's critical, Your Honor, that the defendant is not only saying these words at the time, and that these words were not contingent upon anything the president may do. In fact, he's suggesting the president, he thinks, is not going to call groups like the militia like the Oath Keepers groups or similar groups to his side, but that he's doing this while gathering leaders in this conspiracy with him while amassing firearms. All right. In summation, at Mr. Rhodes' trial, the government reiterated that the events on January 6th happened despite President Trump, not because of him. Ooh, this should be good. Who filed this? Oh my gosh. Now, to be clear, ladies and gentlemen, the government has not alleged here that as early as November, these defendants had their eyes on January 6th, because how could they? They did not know at that point that it would get that far. They hoped against hope that President Trump or someone would intercede to stop this before it got that far. But you know that as things transpired and things moved forward into the month of December, it seemed less and less likely that was going to happen. And it seemed more and more likely that the defendants would have to take matters into their own hands. Rudy, is Rudy writing this? I wonder. Mr. Rhodes was clear in these open letters that if President Trump didn't take action, he and his co-conspirators would. The president didn't take action. No one did step in and throw out the results and hold a new one. And so Mr. Rhodes and his co-conspirators began focusing on the steps they would take to action themselves. Oh my goodness. Bologna sandwiches. Yikes. So that is why you know, ladies and gentlemen, that as of November transpired into December, this agreement by the defendants to oppose the lawful transfer of power by force began to have this second or more crystallized focus of stopping the certification proceeding that was scheduled to happen on January 6th and to prevent members of Congress from doing their duties in certifying the election. For the prosecution to now reverse course and dishonestly claim that President Trump is responsible despite not charging him and previously denying his culpability is entirely specious. Okay? The prosecution also does not deny or distinguish any cases cited by President Trump in which the courts in this district struck allegations in an indictment that did not relate to a charge against the defendant. I don't know how that's relevant. The prosecution cites multiple decisions in which the evidence at issue related to the actual defendant's other actions, not actions by third parties like those who entered the Capitol. The only case cited by the prosecution involving actions of third parties involved events mentioning in passing that did not become the focus of the trial and included no in-depth discussion. Yet the prosecution here has cynically made January 6th the heart of its case, which is the opposite of Looking Cloud, which is the case that they're citing. Okay, that's not true. How's Rudy still an attorney? He has lost his license. Oh my gosh. Finally, the prosecution pretends that relevance already has been recognized. Contrary to the prosecution's claim, President Trump's motion to strike is consistent with other filings identified by the prosecution. It is true, as stated by both the motion to strike and the motion for leave to serve Rule 17c subpoenas, so that was the request for production, that the indictment raises certain allegations about January 6th. The motion to strike seeks to remove those allegations, and the Prosecution cites no authority for the suggestion that President Trump is precluded from the proceeding in the alternative by seeking to collect evidence to defend himself against those unfair allegations, should the court permit them to be presented to the jury. Had President Trump not proceeded in parallel with these motions, the prosecution surely would have argued that he waived at least one of his options. Statements in President Trump's other filings recognize only that the indictment alleges which this motion seeks to strike. That's a lot. That's a lot of bologna sandwich. That's a big bologna sandwich. That's a lot. All right, number 2. The January 6 allegations are not relevant to motive or intent. As an alternative relevance ground, the prosecution argues that its allegations relating to January 6th help shows the defendant's motive and intent. This argument is meritless. Despite 3 pages of narrative, the prosecution only suggests that one of the paragraphs that is the subject to the motion to strike is appropriate for this person, paragraph 111, which relates to the social media post by President Trump concerning Mike Pence. Paragraph 111 does not show motive or intent as it relates to the actions at the Capitol. To the contrary, it reflects protected speech by the President of the United States regarding the integrity of this, which was a matter he had every right and indeed a duty to be concerned about. The fact that the prosecution resorts to Rule 404B to defend its allegations illustrates how far afield these claims are to the charges actually alleged in the indictment. All right, so let's take a look real quick at paragraph 111, everybody, since I just happen to have it here. All right, let's see what he's talking about. Paragraph 111. Oh my goodness. Goodness. All right, here we go. Paragraph 111. All right, 110. So here's 111. At 2:24 p.m., after advisors had left the defendant alone in his dining room, the defendant issued a tweet intended to further delay and obstruct this certification. Quote, Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones which they were asked to previously certify. USA demands the truth. All right, so that's paragraph 111. So they're saying here that paragraph 111 here is protected speech, is what they're saying. I don't know, everybody. It's thin. Tea break. That's thin. It sounds thin to me. Thin. Okay, we're almost to the end. We're coming down to the finish line. I've got Fritos. Oh my gosh, Fritos are the best. All right, we're coming to the finish line here. All right, I don't know about this 111. Thin. The January 6 allegations are not relevant to provide context. As a final futile attempt to establish relevance, the prosecution argues that the actions at the Capitol on January 6th provide, quote, necessary context for all the charged conduct. Nevertheless, again, the prosecution did not charge President Trump with any crime relating to actions at the Capitol. But there was a proceeding going on, right? Lose brain cells whenever we go through emotion. I feel that way too. Sometimes I feel that way as well. Such as an insurrection or incitement. Again, this is wrong. Actions by others whom the prosecution does not claim were part of any of the alleged conspiracy. Isn't this literally what the case is about? It is. It really is. The alleged conspiracies do not provide any context for those actions based on which President Trump is charged. The breadth of the indictment's January 6 allegation also stretches far beyond providing context and background. The prosecution claims that, quote, details about the actions of the crowd at the Capitol explain events that the defendant set in motion, end quote. However, President Trump is not charged with triggering the events at the Capitol. The prosecution carefully avoided doing so. So they're saying because he's not charged with it? So wait a minute. Because he's not charged with it, then he didn't do it. That's an interesting way of looking at it, I think. Well, they didn't charge him, so he must not have done it. Oh my gosh. All right, so despite the lack of evidence, the prosecution seeks to attribute guilt to President Trump for crimes it did not charge based on the actions of others. This is an effort to cause unfair pretrial prejudice by including irrelevant allegations in the charging instrument rather than irrelevant context. The challenged allegations' lack of relevance to the charges against President Trump is further demonstrated by the indictment itself. The indictment claims that President Trump and his co-conspirators committed one or more of the acts to affect the object of the conspiracy alleged in a list of paragraphs. The indictment omits paragraphs 10D, 105, and so on from this list. Thus, the prosecution does not claim that the actions at the Capitol on January 6 were acts to affect the object of the conspiracy, an admission that these paragraphs lack relevance to the charged conduct. That's not how that analysis works. Oh, dear. Oh, my goodness. As the court in the Wilkins case cited by the prosecution explained, allowing admission of issues utterly tangential to the core issues before the court risks allowing the trial to devolve into a mini-trial. Collateral allegations of actions not involving President Trump and are not relating to any element of the charged offenses are inflammatory and prejudicial and should therefore be stricken. All right, last page, everybody. We're going to make it. We're going to make it through. We're going to do it. All right. Next, prejudice has resulted and will continue from the inflammatory allegations. All right. Even if the prosecution is correct that the court does not provide the jury a copy of the indictment. What do you mean, even if the prosecution is correct? What? That's ridiculous. The challenged paragraphs remain prejudicial to President Trump because these inflammatory allegations are being presented to the jury pool. The prosecution's reliance on this case is easily dispatched. In that case, the Third Circuit based its decision to deny a claim of prejudice on the absence of any evidence that the jury was exposed to third superseding indictment, which the defendant did not contest. Voluminous evidence exists here that the jury pool has been and continues to be exposed to the indictment and its inflammatory and prejudicial allegations through media coverage relating to the case. This ongoing exposure is another reason that the allegations should be struck. Me and my 3 brain cells need some tea. All right, everyone, it's the conclusion. We're getting there. Oh my gosh, we're getting there. Conclusion. The indictment's allegations about the actions at the Capitol on January 6th are not relevant because they do not involve President Trump or relate to the elements of any charge against President Trump. These allegations are inflammatory and prejudicial because their purpose is to attack President Trump's character through false allegations that will require a mini-trial and are collateral to the charges the prosecution filed. President Trump respectfully requests that the court grant the motion to strike. All right, we made it. Oh, we made it. So that happened. Let's get to the order. Oh my gosh. That was a lot, everybody. So now we're worried about the media. That's not what they were saying during the gag order hearing. Oh my gosh. That was a lot. It was a lot, Olga. You're absolutely correct. So let's see what the judge has to say. All right, let's see. That was torture. It really was. I can't disagree. All right, let me get a sticky note out because I know a lot of new people are joining. So let me get a sticky note here. We don't deal in conspiracy theories. No, we do not. We certainly do not. That is a big no-no here. Oh, there's lots of other, that's pretty. There's lots of places that love a good conspiracy theory. That place is not here. So, all right, this is the DC case. And this is the order on the motion to strike. Okay, so let's go through. This is only 3 pages as would be proper. So we will see what the judge says here. Yes. It's not even baloney. It's pre-baloney. Yikes. Oh my goodness. Oh my gosh. That was a lot. It was, everybody. It was. I'm thankful I didn't have to go through it alone. I appreciate that. I appreciate the support. All right, here we go. Let me get my sticky note ready and then we'll dive into this order. Oh my goodness. Thank you. Oh, that was adorable. All right, everyone, here's my sticky note. Now let's get back into it. The truth coming. Oh my gosh. Really excited about the response. I am too. No, I am too. I'm very excited. Like, what is this judge going to do with all this bologna sandwiches here? All right, here we go. Let's dive in. Let me make sure I'm in frame here. All right. We suffered together. It's collective. It certainly is. It certainly is. All right, here we go. Defendant has filed a motion to strike inflammatory allegations from the indictment. The motion asks the courts to strike paragraphs 10D and 105 to 13 of the indictment. Those paragraphs allege that on January 6th, the defendant and co-conspirators repeated knowingly false claims of this to gathered supporters, falsely told them that the vice president had the authority to and might alter these, and directed them to the Capitol to obstruct the certification proceeding and exert pressure on the vice president to take fraudulent actions that he had previously refused, and that after the supporters broke through the barriers cordoning off Capitol grounds, violently attacked law enforcement officers, and breached the building, defendant refused to issue a calming message aimed at the rioters and instead issued a tweet intended to further delay and obstruct the certification, attacking Mike Pence for failing to halt the certification proceedings. The court will deny defendant's motions. All right. Yay. Let's just highlight that, everybody. We need this like a peppermint. Let's just highlight our peppermint moment here. We're going to deny the motion. Oh, my goodness. Federal Rule of Criminal Procedures 7D provides that a court may strike surplusage from the indictment or information upon the defendant's motion. That rule has been strictly construed against striking surplusage. So hold on 1 minute. Let me grab the rule. Surplusage. All right, Rule 7D. So let's take a look. Rule 7D real quick. Rule 7, the indictment and information, deny it in bold. Here it is. There's an entire rule just on surplusage. Upon the defendant's motion, the court may strike surplusage from the indictment or information. Well, I'll be. That's my new favorite word, too. I love it. All right. So, and she's also quoting a case here. So she's using U.S. v. Jordan. So motions like defendants are highly disfavored in this circuit. That's another big word from Elmo. So she's motions like the defendants are highly disfavored. Again, that's a great line. I love that. Oh, this judge. All right. They should be granted only if it is clear that the allegations, let me make sure I'm in frame again. The allegations are not relevant to the charge and are inflammatory and prejudicial. If an allegation is relevant or is not inflammatory or prejudicial, the motion should be denied. Oh my goodness. Regardless of whether the allegations at issue are relevant, defendant has not satisfied his burden to clearly show that they are prejudicial. He argues that sharing the allegations with the jury may result in prejudice at this trial because members of the jury may wrongfully impute fault to him for the actions at the Capitol on January 6th. And then she's citing the motion here, arguing the jury might decline to give defendants the benefit of reasonable doubt due to extraneous allegations. But consistent with its past practice, this court will not provide a copy of the indictment to jurors, eliminating that source of potential prejudice. And we're citing case law. Since it's the practice of this court to provide a copy of the indictment to the jury in all cases, there's the possibility of prejudice resulting from irrelevant and inflammatory allegations. Citing case law. The indictment was neither shown nor read to the jury and could not have prejudiced its deliberations. Citing more case law here, the district court carefully prevented the jury from being prejudiced by the challenged allegations by providing the jury with only a summary of the indictment that did not include references to the allegations at issue. Defendant's 16-page reply in support of the motion, which we just went through, everybody. I love when the judge tells us how long it was, because that means she's frustrated. It was too long. It was too long. despite making numerous inflammatory and unsupported accusations of its own. True story. Like President Biden directed the Department of Justice to prosecute his leading opponent for the presidency. See, I took points off for that one. Through the calculated leak to the New York Times. I thought that was pretty intense. All right. Devotes only a single paragraph to the prejudice requirement. 200,000. Thank you, everybody. Thank you very much. His sole argument is that even if the jury does not receive a copy of the indictment, voluminous evidence exists here that the jury pool has been and continues to be exposed to the indictment and its inflammatory prejudicial allegations through media coverage relating to the case. But defendant fails to cite even one example of that evidence. In any event, the voir dire process will allow the court to examine and address the effects of pretrial publicity, including any generated by the defendant and has had on the impartiality of potential jurors. I just find it so interesting that they're arguing this when their arguments regarding the gag order were completely opposite. When trial begins, the court will take steps to screen from the jury any irrelevant and prejudicial material that either party seeks to introduce, which is the judge's job. Moreover, because the jurors deliberate, the court will instruct them on the actual charges and the evidence they may consider in their deliberations, which is what they do. Providing that jury instructions would make clear to jurors that the defendants are actually charged with and that the verdict form will not ask the jury to consider issues for which the defendants have not been charged. This, too, will prevent potential prejudice from the alleged surplusage. Oh, my goodness. For these reasons, defendant's motion to strike inflammatory allegations from the indictment is hereby denied. All right. Yay, Judge Chutkan comes in, the voice of ration. So we appreciate that. All right, so there we go. Release the Kraken. And the Kraken turned back. No. I thought she did a very good job. She didn't even need to, it's 3 pages versus his, 16-page motion, right? So she's like, look, you're saying a bunch of stuff that's not true. And you didn't support your relevance argument, which is also true. So I thought that was well stated. I thought she really was concise about it. Yeah, it's a lot. And it goes to show, too, that, we can really put a lot into our motions. Now, keep in mind in the civil case, remember, Trump's attorneys were sanctioned for filing frivolous motions, not just because there were so many, but also the context. So the content of the motions was frivolous as well. So they had these huge, thick motions they were filing in New York, and they were sanctioned. They were also sanctioned in the Florida case, in the lawsuit against Ms. Clinton. So they had been sanctioned for filing those kinds of motions as well, almost $1 million. So it is possible to sanction attorneys for filing. Now, keep in mind, those were 2 civil cases where his attorneys were sanctioned. They've not been sanctioned in criminal cases as of yet. They've been admonished out of Michigan. They were admonished, but they've not been sanctioned out of criminal court. So it's a very interesting situation where we have attorneys filing this kind of, filing this kind of a motion where it's so clearly, blatantly putting false information out there, but the judge is not having it. She's also one of the judges that presided over a ton of the people who were charged with January 6th. So she's been involved in this for a very long time. A lot of disbarment hearings. Murray, you're right. Now, let me show you the picture again, everybody. So beware. I'm going to put the picture back up. But all of the blue triangles are attorneys that were involved in this case. We've got so many attorneys involved. Clark, Chesbrough, Powell, Ellis, Smith, Giuliani, Eastman, Cheeley. There are so many. So the elephant's moving. There are so many attorneys that have been involved in this case. And many of them are going to lose their licenses if they haven't already or in the process. So we know Giuliani has lost his license to practice. Eastman's fighting for his in California. That's turned into a very interesting situation. California's not having it. Clark's also fighting for his as well. Clark filed a motion saying he was so busy trying to keep his license that his trial schedule was getting booked up. So there's a lot going on there. Now we do have, we had a disbarment filed, or we had a claim filed against Miss Powell in Texas. That was dismissed last February. Now she has pled guilty, so some would say that would be grounds again to file against her in Texas again. So that may happen. A new filing may come down soon for her. Ellis was admonished already out of Colorado, I believe. And Cheesebro is also fighting for his license at the same time. So they are all fighting to keep their licenses or have lost it or in the process of losing it. You think Trump and the co are stressed? They seem to be very nonchalant and unbothered. I think you have to be. I think, there is a certain kind of stance that you have to take publicly when you are being dragged through it this much. You've got to be very, you have to appear like it's not bothering you at all. But I believe absolutely it's breaking everybody down. Every time you say fight for their license, I hear fighting for their... No, their license. Law license. Nope, just their law license. And rightfully so. I mean, we have ethics we have to follow. And, lawyers, we get a bad rap anyway. And now we've got a whole bunch of them here that were involved. And you have to wonder, too, like, how far would this have gone if there hadn't have been these attorneys trying to come in and say, well, let's just look at the Constitution differently. Let's just look at the law differently and see what happens. Like, let's file 62 lawsuits and have 61 of them dismissed. I mean, come on. It's like this accountability needs to be set into place. No sympathy for the attorneys that got pulled into this. Absolutely none. This was by their choice. They chose to go down the dark road, the dark path, and this is what happens. It's like they're poisoning the well. The well has been poisoned, everyone. It absolutely has been poisoned. We are going to struggle for the next multiple cycles of elections. The validity of our elections have now been called in. And the biggest problem is that, evidence seems to be, not the key piece. And for me to see a case or an argument where people are saying, yes, there is the evidence, that evidence, yes, but I'm just not going to look at it. Like, what? How does that happen? Like, there's evidence. Credibility of attorneys. Absolutely. Absolutely. I would say our profession's taken a huge hit, and rightfully so. Rightfully so. Another great job. Thanks, Julie. I appreciate that. Yeah, I think, I think we should all be wary. I think the fact that these several people were in positions where they were able to, speak to someone who had the authority to put this into motion is scary. Why does it take so long to convict? It's not. This is very typical schedule. This seems, our criminal cases are not open and shut cases. They take a long time, especially after Speedy's been waived. They just take a long time, especially because these aren't the only cases these prosecutors have either. There's just a lot. So, they've got to take care of the rest of their caseload. This isn't the only one. Are you going to cover Trump's lawsuit against the media companies? I have. So, he sued multiple times, and they've been dismissed. There was one against CNN actually, for defamation that was dismissed, and he was admonished actually by the judge. So there've been a lot of lawsuits, and they keep getting dismissed. So worrying to see this many attorneys lying to courts, etc., makes me wonder about other things out there. So I'm not sure that, we would categorize it as lying. I would say we would categorize it as Um, Yeah, it's lying. I don't know, man. That's bad. It's not good. I can't put myself in the shoes of the attorneys filing these motions because it seems so fundamentally incorrect. Like I have to be careful with my ethics because there's certain things I'm not supposed to say about our profession, about other lawyers and sitting judges. So I have to be careful about how I criticize the situation. But it's so foreign in my mind when I read through these motions and I read how inaccurate they are and the false statements that are included. It absolutely blows my mind that these attorneys get away with it. It blows my mind. This is unacceptable behavior. These attorneys are filing unacceptable motions. They're putting false information into these motions. They know it. We know it. The judge knows it. They're doing it anyway. It's frustrating. It's hard to watch. It's hard to watch. Yeah, wouldn't an innocent person want to speed the process, especially? Oh, I don't know. I don't know. You're doing a great job. Oh, thanks, Hazel. I appreciate that. You crossed that line. Well, it's tough. It's tough. They don't get away with it. Yeah, I mean, you don't recover. And the other thing you have to think about too is they'll have to justify it to themselves in some way. We all have to do that when we are practicing in court, when we are fighting for a client. We have to justify our behavior to ourselves in order to be able to live with ourselves. So we have to be able to say, I have to do this because I believe in my client. I believe in this issue. I believe in it. So, I need to do what I'm doing in order to go forward in what I believe in. You have to somehow justify it to yourself. But when everything lands at the end, when it's all over, and you look back and you look at those justifications, like you have to live with yourself. And that's something that is incredibly difficult to do sometimes. You're one of the good lawyers. Oh, thank you. Do you think this will make them get clients in the future? I have no idea. I think the kind of clients that will be knocking on their door is going to take a change. I think that's going to be different. Comment on the volume of discovery materials in the case. Oops, whoops. Sorry, I missed that other comment. What are your thoughts on people trying to imply that those who took pleas are being forced to lie? So, yeah, my thought is, we plead out like 96% of our cases. 96% of our cases plead out. And if it wasn't that way, we wouldn't be able to get anything done in criminal court. We'd have too many trials going on. All the time we would have trials. So we have to have pleas. I have no doubt that we will have more pleas coming from this group as well. It's just the process. It's part of the process. So I would say, are they being forced to lie? Absolutely not. No one is forcing anybody to lie. The only thing that's happening is that they're going to try to CYA. They're going to try to cover what's happened. Because if you think about anybody else involved in this that's not actually included in this picture, but other actors that have been involved, their lives are destroyed. And so they're hiding. They're not talking to their colleagues. They're not talking to their previous employers. There's all kinds of things going on. So we've got some people here who have pled guilty. It's very public. They're going to need to do what they need to do to protect themselves. And so they're going to say what they need to say. And what's the first thing you're going to say? Well, I had to do it. They said I had to say these things in order for me to be free. So I was forced to say it. I mean, that's like the number one excuse people use. So it makes sense that that would be something that would be referred to. It's referring to Trump's latest lawsuit filed against the media over report of Truth Social. I'm not sure. Truth Social is having some issues right now that they have got the pleas they have. I'm not. Just statistically, I would say I would be surprised if we do not see some more guilty pleas coming in very, very soon. Statistically, that's how it goes. Now, I think there will be a handful of these defendants who will play hard and will want to go the full distance, like Giuliani, Trump, no doubt. Eastman will probably go the full way. I don't know what's going on with Schaefer. It seems like I don't know. He's got his own goals going on. He's got a loyalty thing going on. So he might do that as well. So I think there's a good handful of people that are going to hold and pull it all the way through trial. But I think for the rest, absolutely, I see pleas coming in. about Trump's attorneys leaking the videos. Well, it was shown that it was Misty Hampton and her attorney that leaked the videos, that set those videos out. So I'm not sure about Meadows. Meadows is unique because of the agreement that he's got going on in DC with Jack Smith. So he's a wild card. I'm not sure what's going to happen with him. Can they take back the plea? No, no, they can't take back the plea. They can violate the plea and go to jail. They can modify the plea, which is what Cheesebro's asking right now, is for modification about his travel, because he's being asked to go to New Mexico and Arizona to give statements and information to the investigators there about the fake electors there. So his is actually being modified, but they can't take back the plea. Judge isn't going to remove Floyd's bond. True. So Floyd just had his hearing, and for bond to be revoked because of statements that he was making on social media. And the judge was, Judge McCarthy was like, I'm not sure. We've got First Amendment stuff going on. I get it. But I think what was most persuasive was Floyd's attorney said, Your Honor, we screwed up. We're not going to do it again. And if you put restrictions on us, we will follow those restrictions. So I think because of that argument, the judge came back and said, all right, well, let's try it again with some new restrictions. I think that's really what happened. Yes, it does cost money to investigate, but it also costs a lot of money to not get the accountability that we need. I mean, can you imagine? So we've got this group of people here in this conspiracy, this huge conspiracy regarding a fundamental principle in our government. And by not investigating it, what kind of an effect is that going to have? Mods are working very hard tonight. Yes, thank you so much. Thank you, moderators. Sydney Powell can say they made her say those things. She can say whatever she wants. She's not, though. She's got conditions in her plea. Like I took everybody through her plea agreement. Part of her plea agreement is she's not supposed to be talking to the media. She's not supposed to be talking to the co-defendants and the witnesses. Those were all things that she agreed to in her plea agreement. Now, if she violates her plea agreement, it can be pulled. So she would have to go into jail. She has to be careful. So I think what you'll find with statements that are actually being, quote, made by Powell is she's not actually saying anything in particular. She's not actually making those statements because those would be a violation. So if those statements are getting out, they're getting out through another way. Maybe she's smart about it. Maybe she's being deceptive about it. We don't know, but there's no way to prove it. And if you can't prove she's saying the statements, then you can't pull that plea. They can't do it. Did Ellis get a felony? So I think with Ellis, I think Cheesebro got a felony. I think Powell pled down. I can't remember if Ellis got a felony or not. Does anyone remember? Guilty of what? Yeah, I mean, they pled to other charges. Couldn't they tell her to shut the site down? Well, I'm not sure why. Ellis was a felony. Okay, she was. Okay, so she was a felony. And I know Cheesebro was a felony. I think it was maybe just Powell that pled to the misdemeanor then. Okay, her statements on PBS plot the overtime. Well, yeah. And see, that's the thing too, though, is that, we do have this fine line here with freedom of speech going on, along with incitement. Now, freedom of speech is not absolute, so it's not completely protected. Like, you can't incite violence, right? You can't, a conspiracy itself is a discussion you have with other people, and a substantial or an overt act in the attempt of doing that conspiracy. That's what a conspiracy is. Conspiracy is words. So First Amendment is not going to protect you, but there are some protections still in place. So we have to, walk this really fine line when we're dealing with this conspiracy issue, along with that First Amendment issue. Can an attorney remain after a felony conviction? Yes, we can. Mm-hmm. Yep. It depends on your jurisdiction. You might lose your license for a while. You may have to modify your practice, but yes, you could still practice, depending on what the felony is, depending on what that is too. So we would take that into consideration. Every jurisdiction's a little bit different. Who would you destroy a career reputation for? No one. For me, I would not destroy my reputation for anyone. I would not be able to sleep at night I figured that out very early in my career. You have to be able to look at yourself in the mirror. And if something isn't important, or you say it doesn't matter, or you look in the mirror and you're like, whatever, I did what I needed to do, then, you've been in the field too long. In my opinion, nobody else in this country. Yeah, I will be the first person to admit it. I mean, I've worked in this field a long time and in criminal law a long time. I have never, ever seen any defendant treated as well as this defendant's being treated. Good night. Yes, thanks for coming. I've never seen the accommodations, the special privileges that have been put out, the special accommodations, the allowances that have been made for this defendant. I've never seen anything like it in my entire life. It's been, I just can't, I didn't think that something like this could actually happen, where a defendant who's clearly been charged at this level is given this much room to do whatever he wants. I've never seen it. And it's just make me want to go back to law school. It's expensive. It's heartbreaking on the one hand. On the other hand, though, it makes sense because the judges, everybody's being so cautious. This isn't one of those whirlwind situations where it's like we're just running down the field or whatever the sports analogy is. This is one of those situations where we are carefully walking each and every single step down this road. Every T is crossed, every I is dotted. So that is one of the reasons why everything is being done with such special care, is because everything is being watched so carefully. So we have to be very careful, and I understand that. But it also is difficult to say, why is this one person getting so much more than anybody else? It doesn't seem fair. It goes against my sense of justice. But it's also something that I just have to put aside and deal with it. I don't think anything's protecting him. I think he realized early on that there are people that will do his bidding for him, and those people are scary, and it's frightening. And they have done damage, and they continue to do damage, and people are afraid, and fear makes you do a lot of things that you normally wouldn't do. And so I think if you've got this core group of people following you that are willing to commit violence, that's scary business. It's scary business. Running for president. Yes, and I think he does feel like it's protection, and it is protection. I think he is absolutely protected by running for president. His speech is getting protected. He's getting all of the accommodations, scheduling, all of that stuff is all being accommodated because it's a huge issue. But he's also running for president because he has the support. If he didn't have the support, he wouldn't be running. He wouldn't be able to run, but he does. So, there are people that are supporting him. That's, part of what our government is that we have people that feel one way and people that feel another way. And, that's difficult. Addresses. Yes. Posting addresses and putting people in harm's way. Yes, it is. It is. And, this is I just can't, I've been looking through a lot of so Mr. Trump had referenced Al Capone recently in one of his speeches and said, I'd been charged more than Al Capone. And I've been looking through Al Capone's records. And the most damaging record, of course, is the one that goes in and talks about his business dealings. And it was through his business dealings they were able to charge him criminally. But even in that situation, the kind of allowances that were made, it seemed like the entire country was ready to go after Al Capone, right? People were ready for that. And they were like, this person has caused so much harm, we're ready. And so there was support. There was a lot of backlash, but there was support. And if you look at this situation now, it's like, would Al Capone be running for president? Would we have that? I don't know. I don't think people, and if so, I'm like, what? Where did I miss that? So it's distressing. It is distressing. How do you feel about the likelihood he'll get jail time? So that's a tough question, and a lot of people want to know. A lot of people want to know, is there going to be jail time? I really don't know. I really cannot predict. I've said before, anytime we're in front of a jury, it's a 50-50 shot, no matter what, with the jury. It's 50-50. It doesn't matter how good your evidence is. That's just how it is. Now, mandatory is in Georgia, the 5 years, so that's the only place where it would absolutely be mandatory. Any other jurisdiction, there's not a required mandatory minimum. So I would say in those cases, he wouldn't necessarily have, I wouldn't think in Florida he would get jail. I wouldn't think in DC he would get jail if he's found guilty, or would get prison, or in New York. I think the only place, can you move the picture? Is it bothering you? I think the only place where jail time would be truly a factor is going to be Georgia. Will be Georgia. Yep. Lifetime of Secret Service. Yep. Yeah, and I mean, accommodations can be made. I think the photo's attracting the trolls. Oh my gosh. No, we don't want that. Let's focus. Let's go back to the calm, peaceful order, everybody. Oh my goodness. No, we don't want the trolls. Oh my gosh. Oh, working so hard. You are working so hard. Yes. The funniest. Why do you think no jail time for DC? Because there's not a lot of jail time on there. He's first-time offender. I think even though the severity of the offenses are significant, I don't know that it would be appropriate for prison time in that particular situation. Can a defendant in any other case in America sue for unequal treatment? Can they? Yeah. But will they win? No. But I'm unlikely to believe that Judge Chutkan or Judge Cannon would find prison to be appropriate for how old he is, for the position that he has in the country, for his criminal record, for the actions himself. I feel that those judges would find other ways for there to be accountability other than prison. So that's what I would say. That's my thought on the on the prison time for Florida and for DC. Should they put him in prison at all? That I don't know. That I really don't know. That's not something, I guess for me personally, I'm undecided at this point. I guess I feel like there are a lot of ways to hold somebody accountable. I don't know that prison is always the answer, but I feel that way about prison for everybody, not just for Mr. Trump. I feel that way when it comes to any prison sentence. I think it's something that needs to be looked at, but that's my overall view. Alcatraz for him and his co-defendants. Anybody else will be locked away. It feels that way. People think he's innocent. And I think that that's true as well. If you don't have a sentence that includes prison time, some people feel like, he wasn't held accountable if he's not going to be put behind bars. But I think that's one of the fundamental problems with our system, is that people think other people need to be in prison in order to, be held accountable. And, I would disagree with that. I don't think prison is always the best answer, but it seems to always be the answer here. He loses power what he holds dear. And I think that's happening in New York. I think that's what's happening in New York right now. Put them out on a ship and float to the ocean. Well, I mean, I don't know. Everybody, there's a lot of different reasons why we have punishment, right? We've got rehabilitation, which was, back in the 60s and 70s. We've got that all changed in the 80s to trying to keep everybody apart, right? So now it's more of a matter of just keeping everyone away from each other. So I just want him gone. I think a lot of people feel that way. People feel that way. House arrest. I would say probation. Probation would absolutely destroy him, in my humble opinion. I think he would be so mad of having to answer to somebody every single day. His privacy would be gone. He would be answering to somebody that he would see as less than him socially. So his probation officer that he would have to talk to all the time and tell him where he was going and what he was doing, His house could be searched. He could be searched. He could drop UAs. I mean, they could hair stat him, you know. I mean, they could do whatever they wanted to do. So I would say, oh, thanks for the vote. I would say, honestly, probation for this person would be worse than prison. In prison, he would be, you know, king of the hill. He would be at the top. He would be pampered and kept separate and, you know, coddled. But if he was on probation where he had to report constantly to somebody else and follow directions, yeah, I think that would be very difficult. Very difficult for him, in my opinion. Again, not my decision, but can you imagine a probation officer going into him and saying, I'm going to need a urine sample, right? Because they can do that. Do they need a warrant? No. Do they need permission? No. All they need to do is ask him, and he has to do it. Can you imagine how frustrating that would be for him? Right. Not in a Texas prison. Well, no ketchup. You know, it's just that idea, though. We've got to figure out, and that's what the judges have to do. They have to figure out what is the most appropriate accountability. Sometimes that's prison. Sometimes it's not prison. Sometimes it's something else. So I'm not sure. You getting bliss with the trolls? Oh, it's okay, Deborah. Let him go. Let him go. Let him run. Let him run free. Give him free reign. It's okay. They don't even have probable cause to test him. They don't even have to. You're right, Kristen. They don't. Good night, Ellie. Thank you. Yes, thank you. Can I be his probation officer? Well, yeah, I think it's going to be tough. What political side? Yeah, yeah, moderators, you've been working so hard. It's okay. It's all right. You can rest. You can rest. It's okay. You can let a few of them come in. It's all right. Yeah, and it ever having one day where he doesn't. Yes, I agree. It's a lot. Trolls. Yes, it is a lot. But again, I think that this question of what the appropriate accountability is would be ultimately, you know, it's going to be up to the judge. But that's different in Georgia. We're in a different position in Georgia, by the way. Again, if he's found guilty in Georgia, that's a mandatory. Maybe go to sub only. I think we're okay. I'm okay letting him go because just letting him run free for a little bit. I probably won't be on for too much longer. So you can just let him run. Just give him the lead there. They can go. Let him run. It's okay. I'll hail the mods. You've all worked so hard. It's all right. Just take a break. Take a break, everybody. Yep. Ignore the trolls. We'll let them pass. Let them pass by. Been working so hard. Yes, have a good night to you as well. Have a good night. I appreciate everyone coming by. Yes, absolutely. Sentence near the board. Oh dear, that's pretty severe. Let them have their fun. Yep, absolutely. It's okay. I'm good at ignoring. Yay! That's a skill. That's a skill set. Could a judge say he could never run for public office of any kind again? You know, that's a great question, actually. You know, I think it's a valid question. I'm not sure because I'm not sure what kind of right you have to run. You know, when it comes to citizenship and those kinds of things, the judges have been very careful. They've been cautioned before to not go that far. So I'm not sure that kind of a sentence would be appropriate. That's a constitutional right that would be difficult to some point. Could he appeal till the end? Yes, he could. Although he might be in jail appealing. If he's sentenced to prison, all of that would still, he would have a report-in date. He would have to show up and report the date that they gave him, even though all of his appeals were still going. So he would still have to go through the regular process that you would go through. So if he was actually sentenced to prison, given a date to show up, he would still have to show up at that date, even if there's an appeal going on. So he would still be going forward with that. That's how that process works. Yes. Oh my gosh, the moderators, you're amazing. Basically, he can do whatever he wants. Well, I don't know. I mean, There are some accommodation. It's just very, very slow running. Do you think he's going to run out of lawyers? That's a really great question. That's a great question. At what point are the attorneys going to just be like, enough? I'm not sure. I'm not sure. I mean, we've got good and bad in all professions, and unfortunately, these attorneys can do a lot of damage. So, thanks to the mods, absolutely. Look at the numbers. Yes, I know. Once you take the power away, yep, as long as you don't give them any oxygen, they snuff out. Send him to the poorhouse. I think he's on his way. I think we've definitely got some things going on. Thank you so much. Absolutely, absolutely. When the money runs out. And that's, I think, one of the motivating factors here, the power and the money. And I think without those as factors, then there's not going to be much left. There's just not. So they're leaving. There must be a rally starting. Oh my gosh, who would want to be his attorney next? I don't know. I've had that question asked a lot. What would I do if for me, would I ever represent him? And I just can't. I cannot figure out what kind of money, what kind of power would be enough for an attorney to turn on their own oath and to go forward like this. Now, don't get me wrong. A lot of attorneys fight the good fights when it comes to doing defense work and when it comes to I'm not here for the client. I'm here for the process. I'm here for the rights. I'm here to make sure the rights are being followed. I get it. And I get people want to have that for Mr. Trump as well. But for me, ethically, no way. No way. I think he has run out. The quality of his lawyers has dropped. It seems that way, doesn't it? Doesn't it kind of seem that way with these motions that continue to be filed? They're just not the quality that they were once, in my humble opinion. And I've been watching for a while. They just don't have that same kind of quality. Fame, good or bad, it can go either way. I think it's what you do with it, right? Yes. Can someone say, well, Trump got away with it? Why can't I? Absolutely. And that's one of the things that we're going to be struggling with from now on when it comes to the elections, is someone can just say, nope, I won. I mean, without any evidence or without any facts. So it's a lot. It's a lot. They can get the judge in Georgia to do the lawyer's job for them. Yeah, I mean, he can ask all he wants, but it doesn't mean it's going to happen. I think we've got... we've got amazing judges going on. And say what you will about Judge Cannon. I know. But I think our judges are solid here. In my opinion, it's solid. Ex-president and president. Well, maybe. Yeah. I mean, again, there's lots of choices out there. There's lots of people to pick from. There's not just one and done here. There's lots of candidates available. So, again, if that's who people want to have on the ballot, that's what they have. If they argue over semantics, they're arguing a weak case, right? It depends, but, arguing semantics is part of our job. Like, that's just part of what we do. We just fight over words and what the words mean. So, I would say here, because they're citing a lot of times their case law incorrectly, their points are pretty weak. I would say there's not a lot of facts or evidence to support their arguments. That's where we're getting some problems. So you can fight what the words mean. I think that's part of our job. But if you can't present any facts or evidence to support where you're coming from, and all you have left is just semantics. Oh, I see where you're coming from. Yeah, I can see that, but I don't know. They're weak. It's weak. Well, he may or may not go to jail. Either way, I'm not here to see anybody go to jail. I'm here to see accountability. You can't violate the law and get away with it. This motion was denied. So he had filed a motion to strike certain statements out of the indictment, and it was denied. So I hope the support falls like the original. Yes, and I think it will. I think it will at some point. But, this is a hard lesson for us to learn in this country. This is the first time that we're really learning this hard lesson. But, it's one of those growing pains that we are all going through. And we'll come out on the other side of it, I have no doubt, but it's a painful process. Can the final order from Colorado be used to affirm the statements in this indictment? I would say the Colorado order can be used as great inspiration. It can be used as a great reference on what to do, how to go about going forward in the trial. But I'm not sure, other than that, what it can actually be used for literally. I would say it's a good action plan, but that's going to really be the extent of it. Permanently out of politics. Yes, yes. I mean, that would be nice, wouldn't it? If we could just kind of cut. But the other thing too, if you think about it, just to remove him, if you cut off the head, I get it. If you remove the leading figure, I get it. But the fundamental ideologies that created the situation are still there. They're still there. The fact that it's possible for him to be the Republican candidate shows how deep a well this is that we are in here. You seen Your Honor holds up his lawyers, yeah, interesting. I should take a look at that. Remove him from politics. Yes. And I think, once that's removed, that's fine. But, I also think, though, I mean, again, in my humble opinion, looking back at my political science background, anytime we have a huge stride forward politically in our government, we always fall back. We always fall back, no matter what it is. And one of the biggest steps forward we ever had was with President Obama and that whole situation for a lot of reasons. So it was a huge step up. So we're going to fall way, way back down before we start rebuilding again. So in my humble opinion, it seems like this was the predictable backlash for being able to make those kinds of strides as quickly as we did. That's what I would say historically, politically, this is how this is going. Which means we are in the rebuilding phase of it. We fell and now we are rebuilding. So I think it's time to, we're going to start to see a bit of change as time goes on. Yes, pendulum theory. Yes, exactly. And it's true. I mean, that's how our Supreme Court has been. That's how a lot of things have gone on in our government from the very beginning. And if you see how we've gone back and forth, again, it's just, that one step forward, two steps back. Oh, Deborah, thank you so much for all of your amazing help. You be influential. I agree. We have to start back up the ladder. We do, but when we go back up the ladder, we rebuild it, and we rebuild it better. That's one of the interesting things about this country, is that we figure out how we messed up and then we rebuild. So I think I have no doubt we are rebuilding. I think we will get there. I think it's just a slow process. So yes, good night. Good night. Yes. Oh, I appreciate it. At this point, so mods are, yes, they are. They deserve more than tea. Oh my gosh. They're amazing. Moderators are no, it's okay. Oh, Cozy and Cray. No, any time you can come and hang, that's great. And if you can't, that's okay too. So, if we have no more elections, then what will we do? We do. I think, we're going to have, I think we figured out, what we did wrong here. I think 7 in Alaska. Oh my gosh. So I think we're definitely in pursuit of rebuilding that ladder. So I think we'll be okay, but it's a hard lesson to learn. No, I think we just figure out how to do things better. I think we screwed up. I think, we weren't paying attention. And things happened. And I think now there's a lot of things in place to make sure that doesn't happen again. We just need to wait it out and not lose focus again. We just can't lose focus. Mods are off. Yes. Do you think Trump could win and pardon himself? No. I don't think so. Yeah, I mean, there's lots of different kinds of revolutions and they're gone. Wow, moderators. Oh my gosh. All right, everybody. I tell you what, my poor moderators have been working so hard. I should go ahead and and kind of get us to my closing arguments for tonight. We are very, very young. This country is extremely young. One citizen, one vote. I agree. I agree. And we got to figure out how to keep the lights on. There's a lot of infighting going on, but I think we'll get through it. We will get through it. It's been a night. It has, DZ. All right, everybody. I will go ahead and sign off. I will be back again tomorrow for one more live before the holidays, and I'll be going through the original treaty that we had with the Cherokee Nation, along with the Mayflower Compact. So I will be going through those tomorrow. And it was great to see everybody. Very special thank you to the moderators. Oh my gosh, you are all amazing angels, and I'm so thankful for your time and energy. And I appreciate everyone coming by and hanging out with me tonight, going through these orders and these updates on these cases. So I will be back again tomorrow to hang out with everybody. So best mods, absolutely the very, very best mods. So thankful. Absolutely. They make it possible to be able to come on here and talk with everybody. So have a wonderful night, everyone. Thank you again for coming by. I will be back again tomorrow. What time? I'm usually 7 o'clock Central Time is the time that seems to work best. So I'll be back around that time again. Thanks again for coming and hanging out, everyone. Have a wonderful night. And again, thank you so much, moderators. You are all amazing. Have a great night and take care, everyone.